I think that would be a job for
Have you taken the consent of the petitioner? You have 40 responded. Have you informed the petitioner? Mrs. S. Brewer,
as well.
learned CGC, appearing for the respondent submits that. Why do you want time for filing affidavit?
The concerned advocate is out of station.
Who?
Petitioners has been informed.
Oh, an adjournment slip has been circulated. Adjournment slip has been circulated by the learned counsel for the respondent for an adjournment. For some same has not been objected to by the learned counsel for the petition. Accordingly, the matter stands adjourned for how many? 2 weeks? 3 weeks?
One.
For a week, 2 weeks. So raised to this matter after 2 weeks on a date to which
In this case, there are other two connected cases, Lokshi. So, Lokshi, may be listed along with these connected cases. Lokshi.
My lord, may I kindly submit my lord before my lord that starts. My lord, may
you want to file an objection in the eye?
Yes, Lokshi, I am.
my lord, may I kindly submit a petition? My lord, may kindly have the interim order, my lord.
We have seen that. What do you want to say?
My lord, the notice that has been issued, my lord, at page number 127, my lord. 127, if my lord kindly has for a moment, my lord. My lord, may I read, my lord? My lord, if it is not.
Is this stayed?
No, my lord, this has to be stayed, my lord. If this is not stayed, my lord,
Then?
we'll be out, my lord.
You file a writ for that. You file a writ. Why should I? How can I stay that in a stay vacating order? This is an application for stay vacating.
Yes, my
In his writ petition, you file your own independent thing. What sort of a prayer are you making? If you want a vacation of that interim direction, we'll consider. We can't pass fresh orders in your favor.
My lord, may I kindly demonstrate my case for a
I don't. I will not understand. You're not the petitioner. How can you present a challenge to an order? If you have any grievance with regard to that interim order passed, make your submissions, we'll consider.
My lord,
Beyond that, no.
my lord, that is the grievance, my lord, because my lord, the OM which has been.
You make your submissions. If
Yes.
the interim order goes, everything goes.
Yes, may I
For
make-
that, this is the first date. We'll have to give him time for filing his objections. When did you file this?
my lord, yesterday,
Yesterday. When was the interim order passed?
my lord, 2012,
2012.
2012.
So you had no grievance till yesterday? Huh?
The notice, this notice, my lord, at page 127, my lord, this has come out on 31st May 25. My lord, exams are going to be conducted on 20 of June, my lord.
Whatever is there, go and participate in the exam.
My lord, only 17, my lord, 19, my lord, 17 posts are available, my lord. Out of that, my lord, only for 9 posts, they are conducting the examination.
This is not under challenge for us in the writ petition. Is this under challenge in the writ petition?
My lord, it is,
Has this got anything to do with the interim order?
my lord, the OM, my lord, which is,
Forget the OM. Is there anything to do with the interim order? Yes, Mr. Upamanu.
Lordship, there is an OM whereby 17 numbers of posts were to be filled up, Lordship.
Fine.
So, Lordship, the petitioners were outside the category, Lordship. They were
Fine.
not overage.
So this
So
court
they
said
came before this.
that in
not to
terms of
disturb.
that OM, don't disturb their services.
Lord.
It has not said you not to proceed with the OM,
No, Lord.
hold these elections.
Yes.
Then
But now, Lordship, what they have done, they have mentioned some other repetition and they have tried to go for the 9 posts, excluding those 8 petitioner who were overage. Lordship.
if that, I am only concerned
So
with
is
this
there-
writ petition.
Yes.
So in this writ petition, whatever is there is there. If we have to consider the interim order vacation, we'll do that today. You make your submissions. We are considering the interim order vacation.
Yes, yes. But I may be able to find an objective to the
When were you served with the copy?
next.
When will you serve with the copy?
Fine.
Today is 11. Okay. We'll have it on Monday. You file your affidavit in the Mr. NH Law Learned Counsel for the opposite party petition submit that he be given 2 days time to file his rejoin his objections to the interlocutory application. So, to the prayer made in the interlocutory application. So, accordingly, Mr. P. Sharma, Learned Counsel for the petition for the applicant, urgency. So, accordingly, registered to this matter again on Tuesday. Tuesday, 17th. 6, when is the exam?
Minus 20, my lord.
On 17th. So, in the meanwhile, the opposite party petition are at liberty to bring on record their objections. No further time will be given.
My lord, definitely I should. But no further, my lord, no money.
Mr. Sharma,
My lord.
try to pick up this art of saying yes.
My-
It's beneficial for you. Or you want me to follow the rule? I'll follow the rule. 2263. When did you file? When did you file? 9. 14 days. 23. We'll have it on 21st. Madam, we are not going to trouble you today. We'll have it on a hearing day so that we can finish up this matter. Because with this, if I start with this, today I think you are prepared with all ammunition. So it will take time. So when? Thursday or next Tuesday?
24. Senior advocate. A very important question is there.
24.
24.
Okay. As agreed to by the Learned Counsel for the respondent. But 24 is again just the vacation week. It will not be a hearing week. It will be a motion week. So have it the week before that. 17th or 19th.
7 will be very.
As agreed to by the Learned Counsel for the party, the restrict to release this matter on 19/6.
He has actually composed after sending the proposal to the finance department regarding sanction or grant of retrospective benefits.
You have not followed up also. So this is now around 20 to 4. So
To get some information. Worship may grant me with 1 week time or like.
Mr. D. Bora, Learned Government Advocate Summits that will be granted a week's time to complete his instruction with regard to the query. Raise 1 week's time to complete this instruction with regard to the outcome of the exercise undertaken by the state correspondence for grant of retrospective effect to the promotion of the petition at the gather of seniors. Accordingly, raised it 2 weeks time. Raised it to list this matter immediately. Raise this matter again on 16/7/2020. Video. Yes,
Should we need some time?
wait. You are appearing for?
Yeah, for Mr. K2.
Okay,
K2.
for PNRD. And that is the only thing you have been doing for the last two days. A small instruction, whether there is any show cause notice issued against the petition. That's all.
It regards to area salary.
It is with regard to regularization of his period of suspension. Huh. So it's with regard to the period of suspension. He was under suspension. Now, whether you have reinstated him, whether you have drawn up any proceeding, and if not, why the period is not regular. We'll have it at 2 o'clock. Get that instruction. Too much time has been.
Wait.
Hmm.
That's what signatures will be minus of the what.
Yeah.
Yes, I got it.
Okay. You satisfied me. Date of death,
That's what, part
2014. Huh. Headmaster, Rupali, over.
Case number 23 9 2014.
Then when did you submit your application?
Roughly within 1 year.
Okay. And where is that first
Roughly
consideration?
Case number 29 roughly. Last page of the the minor.
This is by the
For comparing
district
my,
level.
comparing my financial statement. Education.
Hmm. Okay. Yes, this is the only thing. What is there?
My lord, out of that three candidates, my lord, the petitioner is a better to.
Why have you not made the others a party respondent? The others are party respondent here. The other competing candidates, they are not party. Your name is?
Mean to go.
Mint. Where is that?
And the two candidate name were proposed, my lord, for Parthopotin Borua and Srimati Vitali Sinor. Last part,
Where?
last part, which is like my.
This one. This one. Final financial status of Gitali.
That one. And before that, Parthopotin Borua. Those two candidates were recommended against one case, one case.
Amrit Boru. No. Pathoprotim
Party
Boru.
protocol.
And where is the comparison of that with the petitioner?
That comprehension network. Also, their amount of income and property, my lord. The petitioner is in a better position. He has 7 acres of land and amount of the EPF received. That is.
Anything more, Mr. Swan?
And Lordship, what we said, Lordship, you join for party, Lordship, not my.
Those things are not very good. They have made, there are two grounds for your rejection. One, the vacancies are not there. Two, better economic conditions. So what error is there? And the death is of 2014. We are now around 11 years down the line. No more compassion. We'll give it a quietness. Let him search for something else. But Mr. Desham, running council for Mr. Chief Learning Comment Advocate appearing body state respondents. Also, the petition by way of instituting the present proceeding has raised the demands with regard has assailed the has raised the demands with regard to non-consideration of this case for appointment of on compassionate grounds in terms of the scheme formulated by the government in this connection. Also, the father of the petition, while working as an headmaster of Rupali Borua LP School, had died in had expired, had died in harness on 23/9/2020. Also, the petitioner thereafter, within the time frame prescribed, had submitted an application for consideration of this case for appointment on compassionate ground. Also, the petitioner's application was placed before the district level scrutiny committee. Also, the said committee on scrutinizing the application submitted by the petition, along with the other applications received of similarly situated aspirants, proceeded to reject the case of the petitioner on the ground that the petitioner was economically better placed than the candidates recommended for appointment on compassionate grounds. Also, this court had required the respondent authorities to produce before to furnish to produce the minutes of the to produce the records of the selection of the consideration made by the district level committee, by the jurisdictional district level committee with regard to the application submitted by the petition for appointment on compassionate grounds. Most of the records have been produced by Mr. Girin today. Most of this court has produced the records and has found that the economics condition of both of the applicants in the fray were duly considered by the respondent authorities, and on such consideration, the case of one Partha Protein Borua and Seniority Italy Sonua were recommended for appointment on compassionate grounds against grade 4 vacancies. Also, with regard to the consideration made in respect of the applicant of the petitioner hearing, the said committee on such consideration being made had proceeded to record that the case of the petitioner was not permissible to be considered in absence of the requisite vacancies being available. Full stop. The district level committee having on consideration of the economic condition of the aspirants before it and having made such recommendation in favor of two candidates who were found to be in necessity of the appointment on compassionate ground in comparison to others, comma, no malafide having been alleged against the members of the district level committee in the present proceedings, comma, and puts comment, comma, this court is of the view that the recommendations as made by the district level committee, both in respect of the petitioner as well as in respect of the candidates recommended for appointment on compassionate grounds, would not mandate an interference. Also, it is to be noted that the district level committee, while rejecting the case of the applicant, had also noticed that there were no vacancies available within the 5% quota for recommending the name of the applicant hearing. Also, in view of the above position, this court is of the considered view that given above, it is also to be noticed that the father of the petitioner had expired on 23/9/2014 and a period of around 11 years have left since the date of death of the father of the petitioner. Also, at this distant point of time, there be no, that there be the immediate necessity existing for the family to have one of its members appointed on compassionate grounds, having also extinguished this court is of the considered view that even that of a direction for a reconsideration of the case of the petitioner also cannot, is also not permissible to be issued. So in view of the above discussion, the present petition is held to be devoid of any merit and accordingly the same stands dismissed. In paragraph 2. Refer decision of developer theory reported the insurance. This one, Mr. Pregu. The records produced by Mr. Pregu is the return. Mr. Burago, in all these cases, the candidates are aspirants of OBC posts.
My lord, in all the analogous cases, my lord, they belong to OBC category, they belong to SC women, SC male.
So in WPC 5031,
Yes,
it is only OBC.
yes. Yes, that is 5031, it is only OBC. Even in item numbers 72829,
7,
my lord, the second item number 7, my lord.
2829.
Yeah, so my lord, he is also belonging to OBC. Then my lord, item number 8, that is 2831, they all belong to SC women and man, male and female.
SC.
SC.
Both.
And then in item number 9, they belong to general category, but EWS category.
Item number 9.
9, that is
2833. 2023. General.
general EWS
EWS.
economically.
Okay.
Now we have a very limited. My lord, kindly take up item number 8 for it. If it is a very.
Ipsita Dutta Burwa.
Yes, ma'am. They all are aspiring candidates and in person to an advertisement dated 25/3/2022, they participated for a post of grade 3, my lord. Now, my lord, there are, my lord, two stages involved in the recruitment process. First stage is the stage of written test, my lord, wherein 175 marks are there and multiple choice questions are there. So all the petitioners, they have qualified at the first stage. They were called to appear at the second stage, which is, my lord, the computer skill test. So which is of 25 marks. So they were all called, they all appeared, my lord, and then they were expecting the results to come out. Now, under the mandate of the law, my lord, which is the act, which is, my lord, Assam Direct Recruit Analogous on a Post Recruitment Act of 2021, and the rules which is framed therein under, my lord, 2022, my lord. The mandate is that, my lord, the committee, that is the state level recruitment commission, after, my lord, holding the examination, they will make a application of the merit list of all the candidates according to their, my lord, marks they have secured and the total marks each candidate has secured. And in each category, my lord, reserve category, they will also highlight the candidate who has been selected at the last, I mean to say, my lord, last selected candidate whosoever has been selected in respective categories. Now, here is the case, my lord, they, by a simple email, has intimated the petitioners, my lord, by saying that your candidature has been rejected without, my lord, disclosing the fact that how much we have secured as a grand total in my lord, in both the two stages.
Even today, you don't know how much
How
you have
much I have
spent.
secured? Number one,
You don't know what the cutoff marks is.
cut of marks is,
It's difficult to accept your proposition that the rules mandate that if there are 30,000 people appearing,
my lord.
you will publish a list containing all the, it can only be to the extent of the number of vacancies after FRBM. So here, if we are not in a position to consider your case, neither you will be in a position to press this application, because even if today the details are given to you, the materials are not before this court to make a challenge to the appointment already effected
Already.
of the persons. So the best way out is we can close this matter, direct the concerned respondent authorities to give you your individual marks along with the cutoff marks of your particular category. And thereafter, if there is any grievance,
I
come
will
back.
still put in the column. Absolutely.
Who is appearing for the State Commission?
Mr. B. Chaudhary, my lord.
Get him, madam. Get Mr. Chaudhary. There is no point otherwise in keeping this matter.
Because on the last occasion, in fact, court, this honorable court have given a direction to produce the contemporaneous records pertaining to how much we have secured. And
We will direct them to give it to you within a particular
Yes,
time
ma'am.
frame along with the cutoff
Absolutely.
marks. That much you are
we
at
are
the
entitled, madam.
minimum.
That minimum courtesy, madam.
That's it. We're entitled. Beyond that, we can do.
Absolutely.
Because this proceeding will not help you.
And
You will have to come back afresh.
absolutely, because they have already.
You have nothing to do.
Conducted a written examination.
Baki computer tests and all was done by somebody else.
No, my lord, there are step level recruitment commission. Second level of test were conducted.
So final results would be with the commission.
Yes.
So we'll get the commission here. Mr. Chaudhary,
Chaudhary will.
come up, tell us when Mr. Chaudhary is available.
Yes, I'm obliged to.
Mr. You are paying for the education department. Why are you appointing them in the provincialized schools? We are interfering with this appointment.
They have filed an affidavit.
You take a fresh decision with regard to Mr. Abedin's case.
They have filed an affidavit, my lord, where we have stated in page 72, my lord.
No,
Already they had.
we are saying whatever benefits you have given him also that you are permitted to withdraw. He will not be regularized as a tutor because that is his grievance. He could not have been regularized as a tutor. We are interfering with that, subject to what he says. You take fresh call, fresh decision whenever you want to take. Yes, Mr. Abedin.
The only thing is over here, yes, what my lord has.
Then that is the end of the matter.
But another thing, the question of taking fresh call. Because they are supposed to do something this year.
That we cannot do that. They'll have to take that
Yeah.
call. If they take it in next 10 years, you wait for 10 years. Thereafter, you will get your relief.
Who exists for 10 years.
That is up to you. But you have existed from 2004 onwards. So your challenge is only on that ground. So we are allowing your challenge.
Yes, sir.
We are setting it aside. And let them, as per your policy, do whatever you want to do.
The only thing what will happen, the lawsuit.
We are allowing your application.
No, I understand, but the lawsuit will feel that rider, they will take a fresh decision.
what I'm getting now,
that will be taken away.
that will be.
You will have to repay the full benefit.
No, I'm not.
This is public money, illegally given to you. We'll ask them to recover.
Not illegally.
Yes, because it could not, your contention is they could not have utilized the 2017 Act for that.
Yes.
So finished. Whenever they want to accommodate you, they'll accommodate you with the press release.
No, they have accommodated.
Under the 2017 Act,
No. What they have done, they have accommodated the people under the screening, when the screening was over.
come to your prayer at page 30.
This one.
Insofar as relates the accommodating the petitioners with prospective effect at a fixed pay under the Assam so-and-so Act 2017. Accommodate so far so directing the to revisit, modify the orders of accommodation dated so far it released to fixed salary provided to the petitioners as per Act of 2017, as well as the condition, we'll say this is bad, the 2017 Act, you have made a statement also that is not applicable to you. So they could not have considered your case under that. So now you go back as you were before this regularization. Let them take a fresh call whenever it's possible.
No, when they have regularized my service under the 17 Act, they were supposed to do it under the elementary rules of 77.
And that's why I said, because there is a cabinet decision, we are interfering with that cabinet decision today, remanding back the matter. Let them take a fresh call. Yes, Mr.
I would say that might not let them, they were supposed to file the affidavit.
And you will recover the full amount paid to them till date under this regularization. Everything will go.
Let them file the affidavit.
No,
on the
what
next-
affidavit is required?
No, no,
They have filed the affidavit
They already filed that. Oh.
and they have justified. Mr. Abedin, you are keeping well. I hope so.
Yes.
You are keeping well.
Yes.
Doesn't seems to. Because I did not get the retort I wanted.
No, the variety is there. But then if your lordship is decided in that line, that
Should I?
it not be appropriate unless and until I.
But
have-
your prayers are to that effect. Your prayers are to that effect.
Then my lord, adjourn the matter, my lord, let it come after the location.
Fine. On the prayer of, but next time you keep yourself ready. If Mr. Abedin is pressing for his prayers, this would be the order. Mr. J. Abedin, learned counsel for the petitioner. Also heard Mr. A. Learned, you are for the Elementary Education Department, and Mr. A. Chalia, learned standing counsel, Finance Department. Standing counsel, so, Mr. Abedin submits that the matter be taken up after the ensuing summer vacations. Puts up. Mr. Chalia submits that in the meantime, he will also file his affidavit. File his affidavit in the matter. Puts up. Accordingly, the registry is directed to list this matter immediately after the ensuing vacations. Them. Yes, Mr. Chaudhary. No. You give it to them.
It's under seal cover.
No. Don't give it under seal cover. Give it to them in writing. Individual marks along with the cutoff of the various categories, including their specific category.
Lordship, there is no cutoff.
Why?
Because, Lordship, the person who gets the mark in terms of their merit, their list is prepared, then it is fed into the computer, the software, as per the this, pay slab and the qualification. There are various posts.
No,
If, Lordship, there
you,
are.
you mean to say that the 30,000 people who have appeared, or 3 lakh people who have appeared, you feed it into the computer.
No, Lordship, the marks are calculated. Then as per the qualification,
So under,
the
under,
number of posts are there.
under FRBM, 10 posts, 10 people.
Yes,
So along with reservation.
everything, Lordship, the.
So you
moment the-
prepared, you prepared that list first.
No, we do not prepare. The software is developed in such a manner, Lordship, if there are 10 posts, the first 10% will get the post. Then the 11 will come if he has given option for another post in the next base line. That's how it is done.
So how do you ensure that a person without that requisite cutoff marks or without that requisite merit position, there may be a chance that because of an error, he might also come in.
No, Lordship, it is while the software does it, it is done under the monitor of experts. And if there is some error, then immediately it gets stopped. And
Just
again,
show me what is there in the seal.
Lordship, Silcover, the marks is from the earlier SEPA board because they conducted the exam.
No. Then the 25 marks you have to add.
Yes, subsequently, but the as per court's order, the marks they have obtained in their written.
Written what we want the final marks.
Yes, madam.
No, it's there are lots of initial there was a particular category was not given. So again, court directed second time to bring it in city government.
What happened, my lord? Initially, court have directed them to produce one of two things: the merit list, including the marks they have secured in the entire examination, my lord. They could only give and the candidates who were selected, my lord, in our respective candidates, respective categories.
It is here, mark obtained by the last candidate. Cutoff mark is in. You are SC, STP, STH, OBC, or this is made by not.
Look at what there you can local.
Bachelor. Okay, there are different educational qualifications. And this may be the marks of the petitions. So you have the cutoff marks now with you here. It will do.
The last selected candidate.
Pinku Deka is a
OBC candidate.
OBC candidate. Okay, things are here. Now communicate that individually to the petitioners. Give it to them in their mail so that there is lesser time taken.
Yeah, probably there was the process, they have applied, then the marks would have been communicated. I think they have not applied. Now it will be required.
Application will not arise.
Maximum of these candidates may be appearing in a selection process for the first time.
Yes, my lord.
So let them also get a bit more experience. They'll do what is required. But today you do that.
Lordship may give that a very.
Today we are passing. The site at the uh, 5031 2829 2831 2832. Hmm? The petitions in the above noted petition who had participated in the recruitment process initiated, just give me the date of the advertisement.
Advertisement is on my
Initial-
lord 25th of March 2008.
Initiated, who had taken part in the recruitment process, initiated while the advertisement dated 25/3/22.
Yes, my lord.
22, issued by the state level recruitment commission for all are for grade 3 posts,
All wait report.
all for grade 3 post. Full stop. The petitioners contend that on conclusion of the first phase of the selection process, that is the written examination, comma, the petitioners having been found qualified to appear in the next segment of the selection process, which constitutes of computer test, oblique other test, oblique interview, comma, the petitioners had duly participated in the second phase of the recruitment process also. However, after conclusion of the recruitment process, the recruiting agency, without publishing the merit list of the candidates selected for the various categories of post involved, had issued communications individually to the petitioners, and therein had indicated that the petitioners were not found suitable. What is the exact word?
That, my lord, is at page 82 of the current petition and official decision. Page 82 is the issue communication which was sent to me. Just giving.
We're indicating there that the petitioner, that each of the petitioner, that indicating there that they are not qualified. Also, the petitioners thereafter took recourse to the provisions of the RTA Act for receiving information with regard to the marks secured by them, as well as the other relevant aspects requisite to understand as to why they were not offered, they were not selected for the post or they were not held eligible for being appointed against the posting. Having failed to get the requisite information from the petitioners have instituted the above noted petition. Also, this court had required the learned standing council, state recruitment, state level recruitment commission, to produce before this court the marks scored by each of the petitioners in the above noted petition, along with the cutoff marks of the various categories involved in the selection process. So, Mr. Chaudhary has today placed before this court the cutoff marks secured by the candidates in the marks secured by the last selected candidate in the various categories available, along with the marks secured by the petitioners in the matter. So, in view of the above position, the petitioners, in terms of the having participated in the selection process, are required to be informed with regard to about their own performance in the selection process, along with the cutoff marks, that is the marks secured by the last candidate in the respective category involved. Full stop. This is required as this is a minimum requirement required to be complied with by the recruiting agents. Full stop. In the case on hand, we find that this court finds that the said minimum requirement has not been complied with by the recruiting agents. Full stop. Accordingly, it is directed that the state level commission, will we put it state level commission or we put some authority of the state level?
Lordship, state level recruitment
Secretary,
secretary or
the secretary of the state level recruitment commission shall, within a period of 15 days from today, intimate each of the petitioners in the above noted petition about the marks scored by them individually in the selection process. Further, the secretary of the commission shall also furnish to each of the candidates the last marks scored by the last candidate appointed in their respective category. Full stop. The petitioners on receipt of such instruction may thereafter submit any grievance with regard to the marks scored by them before the commission. And in the event of filing of any such application, the commission shall give it its due consideration in accordance with law. Full stop. With the above observations and directions, the present petition stands closed. The records produced by Mr. Chaudhary is returned to him. I think that will serve.
I'm highly obliged. All the cases, madam.
All the cases.
I'm highly obliged.
What you're gonna be about? Yes. Oh, forget their affidavit. You tell me. How many times should a person be given a consideration according to you?
One time.
One time. How many times have you got?
Yes. Second time.
Same result? Anything more?
Can get face
44. When was the death of your father?
2007. 28/10/2007.
Mr. Hawk, you are there? Item number 11. Yes, page 44.
Annex I. May I read? This is a letter being the Undersecretary to the Government of Assam for submission of data of the present petitioner regarding appointment of professional staff and the petitioner's name in serial number 2. Accordingly, the executive engineer submitted the data in respect of the present petitioner.
Where is your second rejection? That is after the High Court's order.
Page 37.
30?
Sir.
Serial number 4.
4.
So what is error here?
That's it. After rejection of this order, that's it.
That is of no consequence. That is of no consequence. Where is the provision that the authorities can cause a review? Is the power of review available? Then,
But
okay, we give up number 1. We give up number 1. What about number 2, number 3, number 4? Can this be changed?
no, sir, number 4 is underqualified.
Forget that. Number 2,
over
10 years. Any further compassion existing?
Actually, Lordship, petitioner was recommended in the year 2000 by the DLC in the year 2008.
Why did you not come? You came before this court only in 2014.
Yes, Lordship.
Why?
Because
How did you survive from 2007 to 2014? Wages, continue with that. Content.
till date, Lordship.
Dismissed. Yes, Mr. Bora, anything? What is your this? What is he writing this? Your undersecretary? Pradeep Kumar Nath?
Yes.
Why is he, where does he get this authority? He says, as per this, if I go deep into it, you may be also in problem. There was already a consideration made by the DLC. Maybe it was not projected properly before because he refers to the DLC meeting for placing before the SLC. He does not even know that the SLC twice had considered your case.
That was in 2018.
It does not. I also don't like it. I can't go beyond more. Satisfied? Or you want to submit anything more? Your name?
M. Decker.
Heard Mr. M. Decker, Learned Counsel for the petition. Also heard Mr. D. Bora. R. Learned. Standing Counsel, PWD, appearing for the respondent number 1, 3, and 5. Also heard Mr. D. Bora, Learned Government Advocate, appearing for the respondent number 2, 2 and 4. Also, the petition in the present proceeding has essay. A speaking order dated. Where is that speaking order page?
37. Page 37. Next hour.
Speaking order dated 22/11/2018, by which the rejection of the candidature of the petition by the state level committee in its meeting held on 19/6/2018 was communicated to the petitioner hearing. Also, the father of the petition, while working as a grade 4 employee in the establishment of the respondent number 5, had died in illness on 28/10/2007. Also, the petitioner submitted an application for consideration of his case for appointment on compassionate grounds before the concerned authority on 9/4/2008. Also, the name of the petition was thereafter placed before the jurisdictional DLC, which had, on consideration of his application, recommended his case for appointment on compassionate grounds in the year 2008. Also, the recommendation of the DLC was placed before the state level committee in its meeting held on 13/2/2014. Also, the state level committee, on consideration of the case of the petition in the light of the recommendation made in his favor by the state level committee, proceeded to reject his application, holding that the petition, that the petitioner could not be accommodated within the 5% reservation mandated for appointment on compassionate grounds. Also, being agreed to by the decision of the SLC, the petition assailed the same before this court by way of filing WPC number 1965/2014. So, the coordinate bench of this court, while order dated 19/11/2015, while being pleased, was pleased to interfere with the was pleased to dispose of the said petition by directing the respondent authorities to have the phase of the petition reconsidered by the state level committee. Full stop. Accordingly, the case of the petition was again placed before the state level committee in its meeting held on 19/6/2018. Full stop. The said state level committee now on consideration of the application submitted by the petitioner in the light of the recommendations existing in its favor by the jurisdictional DLC, was pleased to reject the case of the petition on the following grounds. One, reject the case of the petitioner on the ground, or reject the case of the petitioner by holding that the 5% quota mandated to be filled up on compassionate grounds in the establishment concerned was already filled up, and that more than 10 years had elapsed since the death of the father of the petitioner. Also, it was also held that the petitioner was in the meanwhile overage and also underqualified for the post in question. The said decision of the state level committee was intimated to the petitioner by the Public Works Department while a communication dated, by the speaking order dated 22/11/2018, which is under challenge in the present proceeding. I've heard the learned counsel for the parties and also peruse the material available on the court. The father of the petitioner had expired, had died in harness on 28/10/2007. Also, the family of the petitioner have thereafter managed to sustain themselves with the resources available to them. Also, considering the long delay occasioning in the matter, today after lapse of around 18 years, with effect from the date of death of the father of the petitioner, this court would not be open to this court to direct for the consideration of the case of the petition on compassionate grounds. Also, bracketer, refer, Devo Brototivari, the number to be the having noticed the above petition, it is also to be noted that the case of the petition was duly considered by the state level committee on a recommendation made in his favor by the district level committee being placed before it, in its meeting held on 13/2015, and had rejected the case of the petitioner on the ground of non-availability of vacancies within the 5% quota. Thereafter, in terms of the directions passed by this court, the proceedings of WPC number 1965/2014, also the state level committee on consideration of the matter and again rejected the case of the petition, holding that there was no vacancy available within the 5% quota for accommodating him in compassionate grounds. Further, the state level committee had also noticed that 10 years had already elapsed since the date of death of the father. Also, accordingly, it cannot be said that the case of the petitioner was not given its due consideration by the state respondents for appointment on compassionate grounds. However, for the reasons noted above, the recommendation in the favor of the petitioner would not be given. For in view of the discussions made herein above, this court is of the considered view that the claim made in the present writ petition would not mandate an acceptance, and accordingly, the writ petition is held to be devoid of any merit. So consequently, the writ petition stands dismissed. However, there would be no other resolution. Sorry.
Okay.
Seen the order dated 27/3/2025 passed by this court in the present proceedings, wherein the coordinate bench had directed for listing the matter after a week for further hearing. Accordingly, it's written further hearing. Further hearing by Justice Epic. I think it will have to go before.
Yeah.
List this matter after a week for further hearing. But it said further hearing. The order says further hearing.
It was not hard at all, my lord, by Justice Katan.
I should not.
Just my submission, because there was an urgency, my lord. He was 76 years old, my lord. He's on deathbed, my lord. Condition is pathetic, my lord.
No, I've seen it, but when there is, we'll directly put to place it immediately. Oh, he is not here.
I'm hearing them around 17, my lord. Very urgent case, my lord. In fact, your lordship passed 3-4 orders, my lord, for reconsideration.
No,
They
very
would reconsider,
Done.
but finally,
Okay, correct. As agreed to by the learned council for the parties, ready to list this matter for admission hearing, for hearing in the admission stage on
17, my lord.
17th.
Hello.
At least. Can you pass it and letter for time?
Oh, body,
For external. And senior English council.
you are second one.
Yes.
You are not entitled.
Not entered. Petition number 2, my lord.
None. Petition number 2. Not given. File a maintenance case. Division bench. Why should we come in all this? File a maintenance case. If you don't get it, come back. Yes. Why are you not paying him? Where is that division bench judgment? There is a division bench judgment on this one. You're not there. Who is your senior? Call it. Let him come. If we can work out something here, fine. Otherwise, you go and file a maintenance case. I think that is the prescription of the division. Get that order of the division bench. Give it. Nothing doing. You can't have a special. Others dismissed today. Why should I give a special consideration? Show me how you are entitled.
Supposed to do,
Whoever it is, you are more than enough. You are satisfied in this court. Why we should give you? There is a reason given.
Let's in another court.
Okay, after some time. Otherwise, I'm dismissing. Same thing. Twice you have given a consideration. When is the date of death? 14.
Yes,
So 10 years, how did you survive?
In the first round of litigation, I have.
Forget it. 2 times you have got your thing. Show me something different.
Survival a person is.
Forget it. You show me what is here problem.
The problem in this SLC lordship, your lordship will find at page number 62. So there was a direction from this honorable court whether the office memorandum which will be applicable in the case of present petitioner in the light of the Supreme Court judgment, lordship, the honorable court has already passed the judgment. That is, your lordship will find at page number.
Okay.
52.
I'm interfering with this. I'm interfering with this. Interfere. Set aside. This decision set aside, take it from me. Now show me your right for passing a direction for reconsideration.
When the district selection committee,
Show me in the light of Devabrata Tiwari that a right still exists as on date after 11 years of the death of your father for a direction for consideration of your case.
your lordship may kindly see in the case of lordship, your lordship will find Secretary to the Gov Department of Education and Primary and others versus Himesh alias Himappa. The applicant father was died.
That is in the facts of that case. Recent judgment. The
Yes,
recent
sir,
one,
this is the judgment of 2021, lordship.
21. So Devabrata is thereafter. 23. And detailed.
Then the lordship, this matter will be fixed on tomorrow, then I will satisfy your lordship
2 o'clock.
on
2 o'clock.
2 o'clock, lordship. I have,
We'll
I
not
have
carry-
another matter, lordship.
Then I'll pass the
Tomorrow,
order.
lordship.
I'll pass the order.
On
I'll
the-
pass the orders. 2 o'clock, 3 o'clock, no problem.
Only because I have to collect the judgment also. Because
I'll provide that. for you.
tomorrow, lordship,
You make
I-
your submissions, Devabrata,
because I
I'll
have to
provide.
be present on that, because in the last occasion, the government, the council for the government, lordship, they place a before this honorable
Oh,
court, that office memorandum that was
Raised it, as prayed for by the learned council for the petitioner, raised it to list this matter again on, I think in Budvar, on Friday for further hearing by
Yes,
street court hearing.
highly approved.
You want to continue?
Yes. But in this case, there was a violation of the interim order. For that, we have filed an additional affidavit on 5/11.
I think that has been withdrawn. No,
No.
you are appearing for the,
And lordship, I appear in the item number 7.
no. The person who has been now allowed to look after the academic charge.
Only academic, sir. The inspector of school is holding the opinion.
Why he has given it to you, not to him?
Only for a school conduct, sir. Lordship may kindly.
He is
see
not
the-
fit, he is not fit for that.
And lordship, here is already a riser, lordship. Lordship may kindly see the first order. In the meantime, the.
You have also filed a writ petition.
Yes. That is there.
I will not answer
Lordship,
petitions also. And in both the cases, it's one
Same
Mr.
order is
Digonto
checked.
Bora.
Yes.
Who is appearing for Digonto Bora?
There is a clear rider. In the meantime, the respondent officers are at liberty to appoint any eligible and senior graduate teacher as principal himself. In accordance with the rule. Till then, the.
Where?
Lordship, the order dated, first order, 28.
In which one? Your case or his
In
case?
this case.
Somebody to file for me. There was a gradation list somewhere.
Yes.
In your case?
Dates. There are many trainings now. Also, if a regular selection is held today, I would be selected and appointed because I have better academic credit than all the other candidates.
That is different thing. This is a post of principal. That post is not within that school. Anybody can apply.
Anybody here.
So
Anybody.
how can you say today that you are the most
That is.
suitable? Then what we do is that we interfere with this order, remand back the matter to the director, require him or her to take steps for regular selection. Till that time, maintaining the seniority in the school without
Also, in that case,
denying
also,
to him-
I'd like that.
denying to him his MA degree, fix whoever it is.
In this case, also, my learned friend's client has also given an NOC. He has
Well,
put
in the
his signature.
That is for you to take up there.
In the meantime, this honorable court has quashed the notification where the NOCs are required.
In Doyananda, we ask it. Not with regard
He
to-
says you have given him a NOC to hold the charge.
They have a broker.
Is it true?
No, that doesn't reflect in my instruction.
And also, and if I go to the also other allegations also may kindly also look into it. I'm not even also sitting in the principal chair. I'm sitting in front chair. Just for a smooth conduct academy affairs. Nothing to do with the also.
These things will not bring in. We are not bringing in these things. These things you take up before your what do you call that director.
There is an inquiry also. He has returned back in amount also. He has under the fund.
Is there a show cause against him?
I-
There is no show cause. But here,
And
But-
when your lordship passed the order, perhaps this order should have been placed by him. This order was earlier also.
which one?
I had filed this petition earlier than my order was passed on 28/2/2024, and his order was passed on 18/3/2024.
Was he a party in this proceeding?
No.
Then how can we attribute that knowledge to him?
Also, when the second petition was moved, I was here sitting and lordship had gone through the order. My learned friend was present.
So both of you have challenged.
Yes.
Literally the same thing.
Yes. Sir. And I am telling on the basis that I'm the senior most and duly qualified.
Was service complete on that Digantapura? Service is complete.
Also, as per Lodhima Court's order also, service is complete. And his name is also reflected. From Jay Kasari.
Filing whatever. 22, okay. Okay, Mr. Katania, what we do is, we interfere with this order of 22, 24. We dismiss your IA, but direct the director within a period of month to settle the seniority amongst you
Yes.
without having any adverse view on your MA
MA
degree. That decision is already there. So that cannot be done. Any department proceeding drawn on that matter against you?
No.
So, but till that time, let him continue as the in charge because we don't want to disturb. The inspector cannot come and do the academic work. He will do the financial work.
Then a time frame may be granted
How
now
will give you a time frame?
within 1 month.
Give you a time frame. Kali logai declare possible. Had the learned council for the parties at length, registry is directed to list this matter again tomorrow for hearing. I'm putting it for admission hearing, but I'll pass the others. All right, move deeply.
What is relating to dismissal from service station. Now, the two proceedings were drawn against the present petitioner. One is criminal proceeding and another is departmental proceeding.
Criminal acquitted,
Yes,
discharged.
yes, sir. So, there is a Supreme Court decision on that.
Ramanlal.
Yes, Ramlal,
Ah,
and another lordship is A.R. Lakshmanan.
show me how
Yeah,
those decisions.
Malak,
These are two different proceedings.
Malak.
The intent is different, the manner is different, and even the application, how you appreciate the evidence is also. Criminal case, it is beyond reasonable doubt. Right? Here it is preponderance of proof. In the criminal case, the court has held only on the basis of the CDR details, The police cannot establish the case against you.
Yes.
One. It has not gone deep into the matter. Here in the inquiry, 3 persons from whom you had taken money had come and deposed. You cross-examined one. You did not cross-examine the other 2. And very categorical statement that, yes, this man took out money forcefully from my pocket. You are an SI. Why should you be continuing in service? Just clarify that.
Malad, apart from that worship, the.
This is not a case for technicalities. There is clear-cut evidence and the proceedings beautifully done. Department.
Malad, 4% allegations were made against 4%.
I am only concerned with the allegation, with the statements deposition in the inquiry.
Yes,
You were given an opportunity to cross and see the beauty in your cross. Come to page 46. This is one Babu Singh Taron. Right?
yes, 46.
46. Second paragraph. Read that. No, 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 no. No. Top portion, second line. Top portion, second paragraph. The delinquent.
The delinquent also asks the PW if he had paid rupees 3,000 to him to the PW reply to the affirmative.
So what he said in this examination in chief, you have affirmed that in the by crossing him on that point. But he has 3,000 rupees taken. Anything more?
Yes, I have some other submissions.
Yes, make. Welcome.
Yes. Malad, 4% allegations were made against 4%. But only one has been the lawsuit.
Now you know the mind of the court where it is. Tentative. Try to dispel that.
Yes. And there was a lawsuit, a joint misconduct. But the petitioner alone was a lawsuit subjected to the particular case. So lawsuit, there is a decision to that effect. If there is a misconduct, joint misconduct, one person cannot be prosecuted.
Okay.
This is one.
Just give me an answer
Yes.
to the query I'm putting to you. The misconduct that you have alleged was committed by you and 3 other police officers. The allegation is that those people were acting under your direction.
Yes, but
You have not denied that.
Malad, he has his direction was wrong. Why this
Okay.
following?
Okay, that is your answer. That is your answer to that query. Okay, done.
They should have objected.
But you accept that those people were acting under your direction.
Yes, that is there. But another one is 4 charges of crime against the present petition.
Let's go to the charges.
In the inquiry report, as well as in the findings of the entry order, there is no voice of the charges has been proved.
Okay.
And they have only said that misconduct or misconduct of the petitioner was proved. But these 4 charges has not been proved.
Now if we can
As
come
per-
to page 33.
Particularly.
The court, these things have been segregated, but it forms one transaction. It happened on the same day.
Same day, but different place.
2 places. One is your Naka and the other one is in the other place. So, but on that same day, you were making all these collections.
Things were 4 charges of crime. So there should be finding.
Okay, fine. Give me noted.
Lordship,
Next point.
rule 9(7) of the.
That inquiry report must be with regard to each of the charges.
Yes,
Noted.
Not only the interim report, it will order.
Order also.
They
Noted.
have,
Noted. Next.
but they realize some citation.
Yes, please. So these are the only two submissions you have.
Well, basically on this.
Only on
also,
these two.
My
Okay.
submission was there.
Okay, then.
Regarding equitable lordship, 2024 one FCC and 2006 4 H. Supreme 740. Lordship, this. So judgment.
Ramlal and Lakshman. Okay.
This. Regarding misconduct lordship,
That is
2010.
GM tank. That is GM tank. Second case is GM tank. Not Lakshmanan. Lakshmanan is the judge who delivered that order. Justice A.R. Lakshmanan and A.R.V. Ravi. No.
I have lordship in my copy. I'm sorry.
Next.
But 2010, 5GLP 371, para 23. Regarding joint misconduct.
Which one? 2000?
10, 5GLP 371. Para 23.
Para 23. Oh, this is different. This is the TRPL case which has been taken. Here it is that a committee in BRPL had fixed the land rates. But only Girish Chandra Sharma had picked up. Then the Supreme Court said, it went from a High Court only. Supreme Court said that no. If the decision is taken by a committee, you cannot proceed against one man. So that will not help you in this case.
2006,
Ah,
there are 2006, 5 FCC, there are 25.
2000?
Yes, there are 25. Just one paragraph.
No, 2006.
2006,
Ah.
5 FCC, 50.
Have you given me copy? Para?
25. It is true that jurisdiction of the court in judicial review is limited. Disciplinary proceedings, however, being Washington criminally lesser, there should be some evidence to prove the fact.
Noted. Noted. Yes. Anything more? Yes. Why? Why we have wordings?
Election put another vote.
At two, Mr. If you can develop further, develop. Think. There are things you can develop. Mr. Das, what are you waiting for? Your respondent is here.
For accommodation for the day.
Why are you keeping the senior waiting? Huh?
Conducting council has some personal difficulty.
Mr. Das, that AP, other posts were cleared, but your thing was not.
They completed the process.
Now, the thing is, you say that they have completed the process, but in the records, you have brought in some other materials, but that final mark sheet and all are not there. Final mark sheets.
They will publish the record, but it has been done.
Have you prepared the final mark sheet also?
Page 96, that letter, page 96.
Letter of the principal.
Principal.
Ah.
It shows value. And in respect of all other posts,
They are filled up, but in your case, they said,
20.
we have not gone to, the second principal has taken a different view. The first one,
First one says,
the first one says he was in your favor. Second one seems to be not in your favor.
but they completed.
Yeah, what is the problem?
The conducted council has some personal difficulty alone. His mother is not well.
Okay. Yes, boss. When?
Any day next week alone.
You are making this prayer on behalf of Mr. R. H. Chaudhary.
RS.
A prayer is made on behalf of Mr. R. H. Chaudhary, learned counsel appearing for the respondent number 4 and 5 for an accommodation in the matter on account of personal inconvenience. Mr. B.D. Das, the learned senior counsel, assisted by Ms. R. Danda, is present for the petition. In view of the above, the registry is directed to list this matter again after 1 week on a date to be. 1 week. Let it be 18/6 on 18/6.
Obliged.
No, no.
My lord, in this case, I am appearing for response number 7, my lord. After filing my ballot now, my lord, the party is not contacting with me, my lord. And one relative's number was provided to me. He is unable to furnish any
Okay.
information.
Ask,
I am.
how old is this lady? Vinamoni Devi?
Hello?
We'll have her here then. She is holding this money on trust. And you have also she is holding this money in trust. 30? 49. He can travel from where? Urupata.
Yeah, my lord, my submission is this, my lord, I am wanted to withdraw my Uttarakhand because
You withdraw, give
Well-
notice and withdraw.
my lord,
You withdraw. We'll have her then. We'll have her here.
my lord,
You have contact.
no.
Huh? Your client can serve a notice of this court on the lady. Huh? Can be done. What's up? Mr. K. U. Ahmed, learned counsel appearing for the respondent number 7 submits that after filing of the wakalatnama, after execution of the wakalatnama, the respondent number 7 has not contacted him. Also, he has also failed to contact the respondent number 7. Also, in view of the above position, also, it is directed that the petitioner shall serve a copy of the present this order, a downloaded copy of this order upon the respondent number 7 and intimate to her that the next date of listing in the present matter is fixed on 19/6/2024, and she would be required to communicate with her learned counsel the instructions are requisite so as to enable the council to apprise this court on the next date of listing of the stand of the respondent number 7 in the matter. First up, on the next date of listing, the learned counsel for the respondent number 7 shall apprise this court as to why the respondent number 7 had not made provision for had not parted with had not shared the pension received by her with the petitioner number 2, who is otherwise eligible to receive the pension. Full stop. In the event by the next date, the said instruction is not available, this court would direct the respondent authorities to take appropriate steps in the matter, which may have the effect of curtailing the pension drawn by the respondent number 7. Mr. B. Sharma, learned counsel, appears for the response number 7. Just give it, let's see.
Alright.
This is not done because you are holding the money in trust. You give a part 2. Sure, you are having a service also. That boy, that lady will not get it. Petition number 1 will not get it. But petition number 2,
This way, my lord, I am calling her science and taken and one relatives who communicated me regularly. I contact with him also.
tell him about this one.
My lord,
I think now they will come.
on the day, my lord, I am providing the letter, which I will.
No, if he comes, get that instruction, let us solve this issue.
That's because if they have not communicated me, how? my
Then
lord,
I'll direct the authorities to make that deduction. AG is here only.
As because as
AG is here only.
she is avoid me.
AG is here,
I
AG
have
will
no
do the.
and in that case.
On the next date, I'll stop the pension.
My lord,
And then they'll come down. It will hit up. You want to take it to please? 17. When did I fix it? 90. 90. You get it, sir. Good.
Please, your lordship, my lord, this matter, my lord, first I have received the brief and also a record. I have received the record file. I will go through the record file, the code. It will be taken up in the next week, sir. I do. So today
Yeah.
I cannot do it. For your lordship, I cannot argue today. Your service matter. And I will have to go through it. At least I have not gone through the content
Tomorrow.
of the affidavit.
Tomorrow.
So tomorrow I will not come. Tomorrow and day.
Have you declared that earlier, that you are not coming tomorrow? I have not seen it anywhere.
No, I have, for your lordship, my lord, I will have to say something. How can I, since your lordship, the record is.
I'll forget, that's the problem.
Record is voluminous. Next time, my lord, next week, my lord, Tuesday, no problem.
Heard Mr. M. Khan, learned counsel for the, you are paying for Mr. Khan. M. Khan, learned counsel for the petitioner. Also heard Mr. T.C. Chutia, learned counsel, appearing for the state for the respondents. Learned additional senior government advocate, appearing for the respondents. Mr. Khan has made his submissions in the matter. Has completed his submissions in the matter. Also, Mr. T.C. Chutia, learned counsel, appearing for the respondent, submits that he would make his submissions, that he has received the records of the matter, and would make his submissions on Tuesday. On Tuesday,
Seventeenth.
17th, after perusal of the said. So accordingly raised to his directive to discuss matter again on 17/6/2025 as a part of matter.
Deeply obliged.
Mr. Abedin, have you received the affidavit filed by the respond number 2?
No.
In the, I think that affidavit is required to be given. Because here it now clear that she is not a resident.
And if my petitioner has also given for engagement order, she has done my.
She has joined. So you be there, we will give it to him. We'll direct a copy to be given to him. Who has filed this affidavit? Dipank or not?
My lord, one thing, your lordship, my repetition that Fozia Tabassum, page 42, your lordship may go through.
Mr. Abedin, the whole game has now changed with this affidavit.
But is it possible?
That's for you
No, I'm
to,
not talking about the affidavit. I'm not talking about the affidavit. Affidavit is the part of the proceeding. What I'm saying about the appointment to the,
they have now come up, they have now clarified that on inquiry, it was found that Fozia Tabuzum is not a resident of that area.
my lord, only once 42 may kindly be seen. It is
Fine,
their,
we'll see everything.
it is their order.
It's everything. We'll see that you will have an affidavit given to you, copy given to you, so that you can also respond. Then we take the matter forward. Heard the learned counsel for the parties. Also, the director, social welfare, has filed an affidavit in WPC number
2162, madam.
2162/2024. Also, however, a copy thereof has not been furnished to Mr. J. Abidin, learned counsel appearing for the respondent number 5. Also, accordingly, the government advocate, Ms. Fukon, you are Deborah. Give him a copy. Accordingly, Mr. D. Bora, learned government advocate, appearing for the respondent number 2, submits that a copy of the said affidavit, along with its enclosures, would be furnished to Mr. J. Abedi during the course of the day. Accordingly, the registry to list this matters again after the immediately on reopening after the ensuing summer vacations. Right? You bring your pleading on record against that.
But date may kindly be given on 16 July or 18th.
16 July. 16 is too much. 21 July. 16 we have fixed up many matters. 21 July.
Deeply obliged. Obliged.
I have not recorded. You continue with your works. You bring that on record by way of filing an affidavit, additional affidavit that you have joined. Even
Lordship, my lord. In this case, what happened, my lord?
Lordship,
The petitioner-
Lordship, Mr. P. Nayak, appears, Lordship, he was in court today, he's not well, Lordship, we had
My
to
lord.
leave the court.
I have a strong objection. Your lordship kindly period last 3 order. Then your lordship see, when on my lord, that first date, my lord, Honorable Justice, my lord, as now has said, you go through the judgment. Then my lord, next day, another government advocate has come. They said, my lord, they have to go through it, my lord. Next day, they said, one notification is complete,
On the last to last occasion, he placed a judgment judgment.
last occasion, no, my lord.
Last to last.
he is making a submission. I'll give you an opportunity.
Next day,
Do you
next-
think this court is so biased that he will not even give you an opportunity to you?
I'm not.
Take your seat. Mr. Chaudhary is making his submissions.
my lord,
Let him
next-
making submissions. Yes, Mr.
Next day, the honorable court is allowed to allow my petition. At that time, there is a notification.
Which was the court? Mr.
Yes, my lord. I have given the order.
I have the orders here, Mr. Don't worry, I have the orders.
Yes, my lord, yes, my lord. Then, my lord, they are not filing the affidavit, my lord. Your lordship, peruse the order. I should not say anything, my lord. Your lordship, can you peruse the orders? This type, my lord, should not be having, my lord. Now, humble somebody, what about this? That is different aspect of the matter.
Mr. Chaudhary,
Yes, my lord.
you are working from, you have the case of Upenda's with you, Upenda's decision.
Yes, my lord. When this case, my lord, now at the one case, I am Dagdu, my lord. Yeah, my client is a Safai Kormosari, my lord. And my lord, he is doing only Safai Kormosari of that office, my lord. Director of sports, my lord. And he was a, my lord, national player. What happened 2013, he was working, my lord, in that department, my lord. Then, my lord, in this case, my lord, all the judgment has been distinguished.
Mr. Chaudhary, there is another judgment after this only.
That
Contrary position to this.
in respect of Safai Kormosari.
Great, casual work, huh?
Yes, ma'am. But
Casual work.
this text is something different, my lord. Because this work is perennial in Nessar, my lord. And my lord, the way, because this work is perennial in Nessar, my lord, that is why, my lord, all the has been distinguished. Your lordship.
Now, what I find is,
Yes, my lord.
they have even denied to you the benefit of Upendas,
Yes, my lord. Pendas.
right?
Yes, my lord.
Just, you have the decision of Upendas.
Well, thereafter, judgment has come, my lord. But
Jago.
yes, my lord. In respect of Safai Kormosari, my lord. Because in Safai Kormosari, there is some different. This work is perennial in Nessar. So, education and qualification, other is not necessary, my lord. So I am reading that paragraph, my lord. Your lordship kindly allow me page 17 and 18, my lord. And my lord, Uma Devi also distinguished, my lord. And read it, my lord, 2-3 paragraph, page 17.
No, just give me that
Yes,
Upendas.
Yes, my lord. Upenda's available, my lord. Upenda's findings is that means of course. It is, however, I give to your lordship.
Just give it.
Upenda's review application has been filed. Therefore, it was done. Now it's pending before the apex court. Because I am appearing in the review case now. So far Jaggu is concerned, I want to show some paragraph, my lord.
Now, where is the direction for regularization in Jagu?
Yes, my lord. Yes, my lord. Lordship kindly come to the, my lord. Para. 26, my lord. And 28. 26, I have my written today. While the judgment in Uma Devi, 28, my lord, in view of the discussion finding above, appeal are allowed, the interim order passed by the Honorable Tribunal are set aside, and the original application is allowed to the extent the termination order that the was, the appearance shall be taken when on duty for the service to be regularized forthwith. 16.2, my. However, they are not entitled for the back wages.
You are working from 2013.
13, I am working, I am the only Sapphire Homosari that is importable. And this work is perennial in national. They never denied in their affidavit, all these things. There are 17, my lord.
Now I've got it.
Let's go.
Yes.
Your Lordship, from last to last occasion, my learned senior had used the judgment of the court. I had not gone through the judgment, that's why I took time. Next date, last occasion, Lordship, I was not present in court because I was in some other court. And my learned senior, Mr. P. Nayak, he had actually placed one, he tried to place one OM, the finance department. I'm not aware of that particular OM. But
They're on
nonetheless,
record.
but nonetheless, what my learned senior is relying on the judge, I went to the judge. This particular case, the present case is totally different from judge. Why? First and foremost, in Jaggo, the petitioners wherein they had been working for the past 20-30 years. And secondly, they were appointed against sanction vacancy. Thirdly, your lordship, here, thirdly, that in that particular case, the petitioners therein were replaced by contractual employees. A particular, their services were terminated, and after that, immediately thereafter, during the pendency of the case between Honorable CAT and the High Court, their services were terminated, and they were replaced by contractual. The Honorable Supreme Court
Outsourced people.
outsourced people. The Honorable Supreme Court said that no, since this particular act shows that they are in employment, they are in perennial nature. That's why they say use the word perennial. Here, Uma Devi was never discussed here also. Uma Devi was totally bypassed. The facts of the Jaggu case are totally different from the present case. Here, the petitioners have been engaged.
No,
also-
Uma Devi has been
Not to that
projected
extent.
to hold that the respondents should not use it as a shield
Correct.
to proceed against such
Yes.
low-level, lowly paid employees.
Yes.
That much only.
Yeah, that was only this. Only this. That the book case only distinguished between what would consider irregular appointment and illegal appointment. Only to that extent. Only to that extent of Uma Devi. Here in this present case, your lordship, the petitioner is admitted case that he was only engaged in year 2013. Now, even minimum pay scale cannot be granted to the petitioner because Upenda's comes into play. Now,
paragraph 22 of Upenda's judgments clearly state. It says that with regards to, I forgot the date from 2017, with effect from 2017,
They
whoever
will
was
be
working.
paid with effect from one. That was, I also forgot, that's why I took the judgment.
Yes, Your Lordship. I also-
1/8/2010. And the undertaking is 10 years prior to
Yes,
that. That would
yes.
be 1/8/2007.
Yes,
So you mean to say because the petitioner had joined after 2007, he will not be even covered by Upendas.
Upenda's.
That spirit will still follow.
My, the affidavit
That
states
spirit
so.
will still follow. Because Upendas was considering a situation of employees who were already there, right? But why will that spirit of Upendas not follow when you had required a hand to do that work and you had engaged with? So that benefit of Upendas will have to flow to them. Jaggo will come later,
And
but
also,
why Upendas will not flow?
Your Lordship, because also in our affidavit, there is a statement at paragraph number 8, why Upenda's will not be applicable. That they have stated there is a finance department OM dated 3rd October 2019. Now that particular OM, in some other case I had went through it, there is a sunset clause that has been imposed by the finance department saying that no application after this particular date will be considered by the finance department. So that, of course, that particular facet of the OM has to be basically challenged also in this particular.
No, no. Let us put it in a different perspective. Upendas came because there was rampant recruitment of people in this. So the state benevolently undertook that we will pay them this money till there. Consequent would be that you will have no further recruitments. But in the meantime, before Upendas came, following that need, he was recruited. So on the date Upendas was delivered, he was existing. So Upendas did not exclude them. What the court said was only reiteration of the undertaking made before. So that spirit will have to.
Can I leave it to your Lordship?
Yes,
I apologize.
we got your point. We'll have Mr.
He was unwell.
Fine. Unwell, if it is unwell, this court will not come in. But you have now heard the
Lordship.
tentative views.
Yes.
I would like an answer on that.
Lordship.
We'll have it shortly.
Any day.
Heard Mr. NNB Chaudhary, learned counsel for the petition. Also heard Mr. D. Bora, also heard Mr. A. Cholia, learned counsel appearing for the respondent number 2. And Mr. D. Bora, learned counsel appearing for the
1, 3, 4, and 5.
for respondents number 1, 3, 4, and 5. Also, Mr. Chalia, learned counsel submits that the learned additional AG, Mr. P. Naik, learned additional AG, is not present in the court today on account of personal inconvenience and accordingly submits that the matter be taken up. Matter be adjourned today and taken up on any date next week. Full stop. Prayer accepted. Registry to list this matter on 19/6/2025 to facilitate Mr. Naik to make his submissions on the matter.
Last time, it is they have said.
But there are no reiteration of.
Because I know, Madam, there is no notification. I know there is no notification. Let them put it.
No, there is a notification that is on record also, Mr.
No, madam.
Yes,
No, madam. That is different aspect of the matter. You know,
that is 3/10/2019.
Yes, my lord. What is the notification, my lord?
It says persons engaged prior to 1/9/2005.
Yes, my lord.
Huh.
That is common notification. That is on the.
No, if this is there, you are also excluded because you are not be prior to, you will get that low amount, but you will not get the higher amount.
Yes, my lord.
Kindly factor in that also. But Upendas, if you read paragraph 22 carefully, my understanding,
Yes, my lord.
subject to what they say, cannot be said to be a one-time sort of a fix. Any person who is there with that criteria of service will have to be excellent.
Yes, sir.
But Jaggo, maybe not.
I said, this is my next statement. Yeah, I find my lord. Because subsequent, I could not find any judgment, my lord.
There is
Statement
one.
of Safai Karmachari. That is why I wrote the.
Mr. Chaudhary, you cannot limit it to Safai Karmachari. All casual workers would have to be placed in one category. You can say Safai worker to show that they are perennial in nature.
Yes, my lord.
To that extent.
That
But
is the perennial
as
in nature.
Safai worker, you
Yes,
can't
sir.
have carve out a category that they are
Yes, sir.
Safai workers, so
Yes,
they
sir.
will be
I am
given.
not Safai, I am
that-
perennial in nature, my lord.
That perennial work
Yes.
you can show.
Yes, madam. That is my lord. Not Safai, my lord, perennial in nature.
Safai Karmachari
yes.
cannot be. They are not a class. We cannot put it. All casual employees
Right.
are equally placed. But to show that they are having perennial nature of
ma'am.
work, you can say that we being working as a Safai nature, our work is daily.
Yes, madam. I said, next day, I have that.
Please. Why is this being hanging like this, Mr. Doctor?
My lord, some instruction.
Now only lifetime areas will be entitled. Release that. You have already
For
processed it.
area, my lord, they already, we have, my lord, we are working on, my lord. And for my lord, pension thing, my lord,
Pension is not entitled.
yes.
It will be the lifetime areas means,
ADR.
lifetime areas means till the death of the father. Thereafter, family pension till the death of the mother. Whatever amount is calculated, his brothers have already given him an undertaking. Pay that amount to him. Compute that.
My lord,
We are monitoring this.
this matter may be fixed after 10 days or 7 days, my lord. We are.
Mr.
Exact-
Doctor Learned, Mr. S. Doctor Learned, Standing Council, PNRD, Department submits that he has received instructions from the respondents represented by him that the claim of the petitioner for being released the lifetime arrears in respect of the pension receivable by his father and the family pension receivable by his mother is being processed, and the same would be taken to its logical conclusion by
My lord, that cannot, I cannot submit, my lord. Instruction is saying different, my lord.
what?
I have to place, my lord, lordship, it's better, my lord, I should file one affidavit.
No
so that
affidavit.
Lordship can overcome that, my lord.
No affidavit.
Because.
You
as per
call
the
your
department, my lord,
people,
my lord.
tell them that this is lifetime areas. What
My lord, as per our department's then, my lord, it's qualifying services is not 20 years not completed. Because they counted from the initial date, my lord.
then you give me that instruction, written
Yes.
instruction. I'll pass the similar order that I used to pass.
Yes, yes, that is. right.
Mr. Doctor submits that the matter be taken up on 16/6/2024 so as to enable him to place on record the written instructions from the respondents as to why the lifetime arrears in respect of the pension receivable by the deceased father of the petitioner and the family pension receivable by the deceased mother of the petitioner is not being released to him.
Lordship is fixing on,
16.
yes, I can post.
12, 16. You give me in writing
Yes,
that.
yes.
We'll pass the
My
similar.
lord. My lord.
Yes, Mr. Why?
We have nothing to do now with the deputy commissioner is there.
Who is the deputy commissioner? Who is appearing? Select list prepared, no appointment.
Yes.
That much only? Who is the government? Yes, so sir. There is a select list. Why the appointment is not being made? Matter is pending from 24 August 24.
And pick them around Monday.
No fixing. Today, call the DC, ask it. Tell me. Every day this matter is being adjourned only on that point. After 1 hour, you call the DC. Tell me. Wait.
What the instruction was.
What? Ah. Okay, we'll take it up after 2 minutes, 2 items. Let him go through the instruction. What is this date 1/1/2011? That is the last date you worked.
That is the day, my lord. They have,
From where did that date come?
up to that day, my lord, they have regularized my service.
With your leave and all.
Yes.
Now, how will you get your salaries beyond that?
Then,
How can that period beyond that be considered for pension?
my lord, this whole court directed them to grant the pension.
Pension after, no issue.
Yes.
But this court did not quantify the qualifying period.
That,
Qualifying period has to be quantified. You will get your pension after 2022, but your qualifying service will be only till 2011.
qualifying service, already 20 years I have completed long.
Till 2011, whatever it is there.
Yeah.
Are you agreeable? I'll pass the order now.
And
Because you can't be illegally enriched.
yes.
You can't, because you are not working after. Because I also was having a doubt as to what was this 2011. Then I came to a conclusion
that
that
date-
that is the period you worked.
Yeah, up to that.
How can beyond that be treated as qualifying service public?
Yeah.
You will get your pension as per the scale of pay drawn by you on that. Agreeable, I'm disposing it, or I will pass orders. What do you have to say?
I have to get the pension, it was long days in advance.
They have released your pension.
Nothing has been released.
So, madam, so with that, till that date, take it from 12/1/22, release it.
Pension which will take effect from last regulation.
No, it will be from 12/1/22, but on the scale of pay of that date, 11.
Now, if my pension is treated with effect from 2011, then I'll be entitled to area with effect from that day only.
That is the mistake they made.
Then I'll be once the two way it cannot be my lord. Either I have to be regularized till my such day, and otherwise
Pay him now.
if the pension is my lord with effect from 11, I
Pay him
agree, my
full
lord, that
areas.
area has to be there.
Pay him full areas.
That is the thing.
But he is not working.
No,
not-
you
that
have
is not-
compulsory retired him from 11, so he is entitled to the benefit from 2011.
Yeah.
Areas,
Let me take it just a minute.
you have your instruction, we'll have it on Monday. Huh? You made a blunder there. And when
Otherwise,
Mr. Purkhaisto is there, be careful. We'll not let these small things go. Hundi Learned Council for the parties. This take up Learned Council. You're standing council?
Yes, for social justice and empowerment.
Hey, go ahead. Social Justice and Empowerment submits that she be granted a week's time to complete her instructions in the matter. Full stop. Registry to list this matter again on 23/6/2020. 23/6/2020.
Yes, part of
You just have an instruction that when it is from 11, you have retired, when he passed the order from 11, compulsory retirement, the seizure occasions on that day. Then the date of 22 is of no relevance. So this period, he'll be entitled to arrears. Right? So even if it is 22, then we'll be asking him to give the pension from 22. This period will go off. Now that you have taken back the date to 22, you get the instruction, how will you do? So the best way was that the second order was uncalled for. The first order you should have stick to. Then the period from 11 to 22, he would have got nothing. From 22, he would have got his pension, but at the scale of 2011. Think over it, do what is required. Come back.
Okay.
You got my point? Yeah. Yes, Mr. Prasad.
Third, I'm checking optional promotion from a date on which, ex-cutter,
Why notional promotion? Other than for the notional fixation of your benefits, what is the other reason? Has your seniority been depressed in any manner because of non-grant of retrospective promotion? It was.
will be
How?
the day the other person was promoted.
He is no longer there. His promotion has been interfered with.
His promotion has been interfered.
So there is
And
none
I was-
above you.
Now the office was directed to consider my candidature.
So they considered it
And they
prospectively.
promoted-
They have given
And
it.
they promoted.
Hmm.
Now, that period from 2018, when he was promoted, till the day when I was promoted in 2023, in between, a lot many employee has been taken into service
How? By what way?
by direct recruit, not by.
Now today, they are all placed above you. So today, if I have to consider this case, how can I do it without hearing?
My case, in 2018, was
I
promoted.
can't consider because you have been given a finality, a position now.
I haven't given a vote.
That is continuing.
But
Now to disturb that position, if I have to give you a seniority, retrospective promotion, it would also tantamount to giving you a retrospective seniority.
now the
That will be affecting a lot many people. They are not before me.
judgment was passed in the earlier case.
Judgment did not say retrospectivity. It is basically prospective.
It did not say anything.
No, it said, when you come in the zone of
If
consideration,
I come into the zone of consideration.
That means
consider my
with what?
candidature.
it is not retrospective, it would be prospective in nature. What is the error there?
If on 2018, I have been unjustly denied.
The court has rectified that position by interfering with the appointments of that two, Sanjeev Das and all. That has been done.
So
Then you have been promoted.
the fact remains, if I am unjustly denied promotion, I can be.
The court did not give you that relief.
Because as on that day, the court could not have given me that.
The
because-
court could have directed for consideration of your case with retrospective against the vacancy that now had arisen. Court did not do it. So how can we go now and sit over that order? Coordinate princess. One. I accept your that plea. Second would be, where are the persons who would now be disturbed? Because a settled position of seniority would be disturbed now.
At page 81, sir. 81.
Hmm?
81.
81. These are the people.
These are-
But they are not before. us.
Serial number 1. is dropped.
Then
And rest are all direct.
whoever they are in the cadre. How they were born, that is different. But they are now incumbents in the cadre of junior assistant, right? So they would be somewhere. When were you given the promotion?
Promotion.
You are at serial number 27.
27.
Now you will be, if I have to take you to 18, you will be over 27 persons. So all these 27 persons have to be given a hearing. And it's not permissible. Because I find that there is no promotee. Sanjeev Kumar Das gone.
Wow.
Kushal Deka,
He has retired.
he has retired,
Kundeka is there. Kundeka is there.
is there. He is senior to you.
He is also an ex-cutter, but I have not challenged her.
Okay. Why have you not challenged?
At that point of time, I didn't know that she was also an ex-cutter.
What is the quota for promotion?
10%.
10%. 27. 10% would be 2.2
2%.
persons. So
Now, there is another thing is eligibility criteria. From the, for promotion, none others have the graduate degree, etc. So there is no other.
Fine, fine. But this retrospectivity would not be permissible. You still have around 5-6 years of service. 69 more, 29. So how can we give you any relief, Mr. Prasad?
Just relying on a decision.
Where is the challenge to your order of promotion?
My other.
That order on account of its prospective effect. Now that is not under challenge. That is finalized. How can you go beyond that? Technical, but you will have to. That is also not under challenge. Because this order, right, wrong, it gives you a,
Yes, sir. Really.
it prescribes something. Now for us to go beyond that, we'll have to interfere with that to the extent of its prospectivity. Not permissible. Because you have not even challenged that. Not asking you to ask for a set aside of the order, challenge to the extent of prospectivity. Not done. And this vacant post is the post held by Sanjeev Das.
But he is still holding that role.
Whether does it mean? Maybe you have been accommodated, but it is literally that post. So he has been paid from that date till the date of his. Huh?
I'm not taking any detail.
Prasad, Mr. Prasad, he has already been paid. Now, how can I be direct for you to be again fixed, even notionally, because that payment is already made to that man. Two payments against one post cannot be made. Huh?
You were holding that post.
That is why it was done away with as the court directed for recovery of the amount. No.
But he has worked. He has worked in that post. Even I have done.
I think you should be satisfied with this. Subject to an appeal. Anything more?
Let's take inspection tomorrow. Let it.
Tomorrow.
Also tomorrow I have some
Friday.
Friday.
As prayed for by Mr. P. Prasad, Learning Council for the petition, and not objected to by Ms. M.D. Pora, Learning Standing Council Transport Department. The matter stands adjourned today. Registered to list this matter again on Friday. Sleep what to do. Just try to take me out from this, what I have told you, then we will see what can.
Lordship, we have done as per this honorable High Court order. We have promoted.
You are a regularized person?
No, you contacted him.
Contractual employee. Wow.
It's not the first time you know that we have been classified.
Huh? Which is the communication violated?
Page 43.
43. Respondent number 6 is very powerful. Huh?
Against earlier also you were, he was quite possible. Against.
Who has transferred you now? Who has transferred you now? CEO. Chief Executive Officer. So he is covering how many districts? More than one district?
Only one district.
One district. When was your order of transfer?
8 August.
Yes,
2000
Mr.
8 August
Doctor.
2020.
I've submitted the instruction I have received. Only 3 pages, my lord. I have marked only. Third page, the interim order, my lord. Last line may be seen.
Yes, Mr. Mira. Where is the first order of your transfer? Before you came to this court? You were appointed in 2/3/2019.
19. Then your lordship kindly tell.
That is at Hailakand.
Yes. Initially, he was appointed as accredited posted at Hailakand.
Hailakandi?
Hailakand.
Ah.
Subsequently, your lordship page annexed to page 20.
He is also a contractual employee.
Yes, please. Then your lordship kindly annexed to page 26. Serial number 81, your lordship page 27. Petitioner was transferred from Hailakand KP to Monachara district. Page 27.
Just.
Serial number 81.
Page 20.
27. Serial number 81. Then your lordship, accordingly, he joined your lordship on page 30, your lordship, on 24th September 2021. Then your lordship annexed 3, your lordship, page 31, he was given additional charge for
So you were accredited engineer Hailakandi.
Hailakand, your lordship.
Now, why this order? Where is your name? At page 26.
Page 27, at page 27, your lordship. His name is your lordship.
Serial number 81.
81.
You were taken to,
Monachara.
you were in Lala block, taken to
Monachara.
Monasera. Okay.
Then your lordship, by order dated 410.
So from earlier onwards, earlier you were not in Hailakandi, you were in Lala
No, live block you.
block
Block.
under Hailakandi district. Okay. This is all Hailakandi only. Okay. Okay.
If lordship want me, I want to work on also. Lordship will kindly come to page number 17.
Coming, we'll come. Let him have his say.
Then your
Then,
lordship, by order dated 410/2021, he was given additional charge of again Hailakand district. In addition to his charge,
where is that?
page 31. Your lordship.
31, your name?
My name appears at page 32, your lordship, serial number 38. Your lordship.
Monasera is a place within Lala development.
Yes.
Or it's a different development. Monasera? Same development. So from here again, you have been page 31. You have been taken from Lala.
No, your lordship. He is an additional charge. Also, in addition to
Serial number?
the 38, page 32.
Okay, this is in addition to Monasera.
One of them.
additional charge of Anakala, right? Aina? Aina. Okay, then,
Then one communication is important, so page 96.
uh,
May I get you? Regarding unauthorized, this is the letter issued by the Commissioner Panchayat and Rural Development Bureau. Regarding unauthorized transfer and attachment orders in respect of local. Last, the second class paragraph may kindly. Henceforth, it is directed not to make any transfer of contractual employees without prior approval of the undersigned. However, in case of exigency, you may submit proposal for transfer justifying the reason of such exigency to this commissioner. Moreover, employees who have not completed 2 years shall not be transferred except on medical grounds or some other exceptional or disciplinary situation with explicit clearance from this commissioner. Then another officer is also issued page 37. Annexure 5. From the commissioner itself. The last, second of paragraph,
page,
page 37. Also regarding personal unit. Further preparation of Ground Panchayat Development Plan for 2023-24 has started. And owing to peak working season of the state
Okay,
for
fine.
implementation of.
okay. Next,
In violation of this communication, the petitioner was referred.
where is
Page
that?
38.
So this is under challenge here.
No. Against that, I'm relying, I'm submitting this, showing that he has earlier also he was transferred in violation of process. Against that, transfer, though he did not approach this court, but he submitted representation before the commission. Then you must kindly tell us by 43, notification by the commission again. Secretary to open the Panchayat and Rail.
What is the date of this? 17/5.
17/5/2020. By this notification, you notice
Deputy Commissioner has
Deputy
been.
Commissioner has been authorized to take that responsibility. And in violation of this notification, your notification was transferred by order dated 25/1/2022.
Page 44.
Page 44. Against that, although he was holding the current repeat monitoring, but in the.
So what happened to your posting from out of Monasera?
That has not been appealed. But in the.
Where are you working now?
In the additional.
What happened to the main one?
Main one, in the HCMS database, so it has been shown that I'm working Monasera GP, but one field I'm working in Monasera, where I have in my additional. Against the order, he approached the honorable court, to WPC 9/5/2024. Order is at page 47.
Okay. Just a minute. You come back to page 38.
Page
38. Okay. This is Pritam Dhar is the respondent.
Record number.
Okay, then what happened?
Against the order dated 25/1/2024,
You have come.
And the petitioner was directed to file representation before the commissioner.
Then you were released and posted at Niz Varnapur, Sarbanandapur, Gaon Panchayat, White Pritam Dhar. Same person. Okay.
When petitioner approached the honorable court, order is at operative part, page 48. After hearing the non-profit for the.
Status quo till.
Yes, yes.
So you preferred a representation. Then what happened?
Accordingly, your lordship, page 53 mechanism. Now, after going through all the relevant reports and in compliance with the judgment passed by the Honorable Consort, page 23 to 2024, the transfer order issued by the Chief Executive Officer, Jilla Police of Hailakandi, so dated 25 January 2024, by which presented that there is a petition and united in which was released from Hailakand, Gaon Panchayat, under Lala Development Board in Hailakandi district and posted in that is Barnapur, Shadwarandapur, Gaon Panchayat, by become the
Okay,
thereby
fine.
satisfied.
Then
Then your lordship. Again, your lordship. That why your lordship, dependency of this order, your lordship, petition, call number 6, your lordship, has denied a sub master role, your lordship, against which petitioner submitted representation, your lordship, page 57, your lordship. Page 57 mechanism. 55, your lordship, 55. Two representations is submitted, your lordship. Inquiry against unauthorized of 9 number of scheme EMR.
forget it, that we are not concerned. Come to page 66.
Because of this representation, your lordship.
Maybe.
He has
This is the order, latest order.
latest order page 66. This is again issued by the Chief Executive Officer. In violation of the notification. Okay,
This much only?
Yes.
Yes, Mr. Doctor.
My lord. Page 53, maybe once again, same. After the last order, it was passed, my lord. The only reason that earlier order was set aside because, my lord, concurrence of the district commissioner was not obtained for the transfer. In the first paragraph itself, my lord.
Where is this order dated 22/2/2024? It is on record, transfer order 22/2/2020, relieving order 22/2/2024, the block development officer. You have 22/2/24.
into order.
Yes.
My lord.
Where are you posted now? Hailakandi where? No, I know that. Where? Which block?
Under Lala Development.
And he?
He also.
Same block,
So you also.
same post. Both of you. Who is drawing the salary? You're drawing. And you? Salary?
Under the Chief Executive.
You're getting your salaries?
Yes, you.
My lord, under the block, different Gaon panchayats. Under block, my lord, different Gaon panchayats are there. And both are, my lord, they have their own post in another thing, my lord. And additionally, these they are doing this,
Where is his original post?
original post, my lord, it's written here only, my lord. Monachera Gaon Panchayat.
He is there.
Yes, this is this original post, my lord. And he is hereby relieved from the impugned order page 66, my lord.
Okay. And the original post of the
Is my lord, Nimai Chandpur Gaon Panchayat.
so you agree that your original post is Monachara?
Yes.
And you also agree that your post is Nimachai Sondrapur, right?
These are additional works, man. And they were, I don't know why they are so much interested.
While you know that in mention is there half like my it's people of this. Apart from the pilot, it's a forum of path. Prior to that, pilot of daily. You'll also kindly verify the reply to the page 75.
You were initially appointed against Ainafam. First, then transferred to Monasera. This order dated 22/9/2021, which we find mentioned. Okay. This order has not been modified at any point of time.
No.
That is still continuing. Okay.
Still, I am holding the additional charge of Aina Khan.
Monachara, you are getting your salaries from Monachara.
One of your parent particular, and at this point, also holding particular charge of Aina Khan.
Aina.
Clearly reflected in the order issued by the PPA. It prays.
Monasera and Aina.
In my reply, it prays the 25.
And he is holding Nimai Sanpur and yes. Nimai Sanpur and
Now, Aina ka hal now, base 66 minutes in there. Base 66, everything is there. Aina hal now, panchayat. Additionally, man.
Aina Khan.
okay. What is this with to do with additional charge? Monasera, you are there. Additional charge only, both of you. You are interfering with that.
And they
You
will
passed
not get
appropriate.
anything, my lord. Any monetary benefit or
Not there.
additional charge, they will not.
What is the fun?
Your Honor, after issuance of the status quo,
You tell me what right of yours is violated.
But what I am holding is the charge lawfully. I have.
You are holding the charge lawfully, hold it in Monachera. Additional charges, both of you cut it. Both of you go back to your original charge, original place.
In this perspective, Your Honor,
Huh? Huh?
All matter may be referred to the commissioner, Your Honor, and I will pass appropriate representation for Your Honor.
Nothing me.
Your Honor.
Or,
This is,
or both may be transferred, my lord, because maybe because of manpower, my lord, they are holding additional. Maybe in another person will come in there.
that's what I'm saying. The additional charges are creating this problem.
Yes, yes.
Both of them, the additional charges, we are interfering with the order dated 66/8/2024. Both the additional charges go. We'll direct that they will continue in their parent posting, wherever it is. And thereafter, if the additional charge is to be given, the government will pass appropriate
My lord,
orders.
as per notification or deputy commissioner. is
Deputy
the-
Commissioner will pass appropriate
Yes,
orders.
yes.
Finished.
Yes, my lord. That-
Why should we always go and see who is holding what and thereafter come in? No right of yours is violated. Show me which right of yours is violated.
By the order,
Which, how can a right be created in an additional post? You are getting nothing from there, or is there something else coming which we can't see? Done. Interfered with. Huh. Hmm. Approval of the Deputy Commissioner. Okay. You have been given Purbo, Kittar, Bonda and Rajeshwarpur. You don't wonder. Additional charge has been given to you also. And Nimai Chandrapur is now holding the charge of, he was holding Purbo Kittar, he is given to you and he has taken Aina Khal. What it's common
It
things.
takes some time to manage new places. That may be.
Dismissed. Hmm? Dismissed. Get the order day after.
High level.
Then I'm getting. Yes, madam.
28, we have received the instruction.
What?
The instruction is that His services were not provisionalized because he was not recommended by the district scrutiny committee.
Why have you not placed this case back after the Supreme Court order? Division bench, single bench orders, 2, 3. Why are you not considering his case? Wherein you have given the same consideration to similarly situated
Yes,
persons.
Your Lordship.
Why?
Lordship, the difficulty that we are facing is that we have not received any proposal from the district scrutiny committee. Your Lordship.
Who will give? Will it coming from air? You will have to put direct them to do it. Once they have done, they have left him out. So if it has to be done the second time, you will have to direct as the director or the commissioner or whatever you are. Otherwise, how can they do it? So when are you going to do it?
Lordship, let me have the instruction. Lordship, let me-
Friday. Friday. On the prayer of the Learned Council for the parties. On the prayer of Ms. Musari, the Musari, Learned Council, Learned Standing Council, Elementary,
Secondly,
Secondary Education Department, raised it to list this matter again on Monday, 16, for further hearing. Just,
yes, Your Lordship.
there are, you can't take that plea now because for this court, Supreme Court both have said that don't do it, give it. How can this poor man be left out? You also have to get that.
Lordship, I'll-
That much only you want, you'll get it.
All right, sir.
Monday. All right. Yes, what is your instruction?
As per instruction, Lordship, petitioners have 3 children. So that is the instruction.
Okay.
Lordship. Sorry for inconvenience, Lord.
That is why you have brought
Yes,
Lordship.
I was thinking yesterday when I saw that act, 3 children amendment, why have you brought it?
Not annexed, Lordship.
For what? Why?
Advertisement.
Why should he, what will he do? He has been selected.
Yes, no, my lord, as part of my lord, that
Kindly come to page 6,
notification
Lordship.
of nothing.
Page 6 of my petition, Lordship.
Huh?
Page 6 of my petition.
Page 6.
Yes.
No, Mr. Council, this is the 19, 19.
This bar is not.
You have annexed this.
Yes, Lordship.
Then
Last person is.
yesterday when I was reading, I made a mark.
I'm sorry, Lordship.
I thought, why did you bring this on record? Now it's
Yes,
clear.
Lordship.
Now tell me, 6.
Last year.
Hmm.
There is a provision, Lordship. Bar will be not applicable if all the children are born prior to 2019. Before coming the notification, Lordship. My youngest son born on 6/9/2018. 6/9/2018. Lordship. So this bar is not applicable for me. Lordship.
So you have 3 children.
Yes, Lord.
What about 2A? 162A, 2A.
Yes, Lordship. 162, 1 Roman 11, Lordship. He or she should not have more than 2 living children from a single or multiple partners, provided that these provisions should not be applicable in respect of those persons who have more than 2 children prior to date of coming into force of this notification dated 19/7/2019.
Okay, now come to next page.
Yes.
2A.
Yes, Lordship. Deputy Commissioner, Principal Secretaries of Autonomous Council areas shall remove any Gavura if he or she is having 2 or more than, if already appointed, Lordship. But this notification is not applicable for me, Lordship. This bar is not applicable for me, Lordship, because my youngest son born on 6/9/2018 prior to coming in force of this notification. So provision is applicable for me, Lordship. 1 Roman 11, provision.
Yes. Mr. Sarodi, what do you say on this?
Lordship, as per this, prior to the Lordship, amendment, Lordship notification, Lordship, is clearly stated that who and
That
what
is,
was-
well, he is correct. That is for already in existence.
Advertisement. Prior to my lord, 19/7/2019. If already we applied, those who do not have the amount of more than the 3 children, 4 children. They are,
Where is that advertisement? Copy of the advertisement?
that,
Not
my lord,
annexed,
that
not
has
annexed,
not been
not
annexed.
Not been annexed.
And the, my lord, there is a
Advertise was
specific
made on-
clause.
There is specific clause in that.
Yes,
Where is that advertisement?
advertisement was made on 26.
You have a copy?
I have no.
Get a copy.
There has been a
The
specific clause.
advertisement was made on
Those who have, my lord, more than 3 children, they cannot be applied for that.
yes, Lordship. But advertisement was made on 26/5/2022.
Hmm.
2022.
We'll go, we'll see. You get that. When? Tuesday.
Moreover, Lordship, it was published in newspaper, Lordship, so it may be difficult for me. It is
Both of you,
available-
either of you. You also get it from the deputy
It
commissioner.
is available with the
The
response.
Learned Council for the parties shall place before this court the advertisement issued on
26/5/2022.
26/5/2022 for recruitment against the post of Gaon Pradhan. Recruitment against the vacant post of Gaon Pradhan in the district of Nalbari. Registered to list this matter again on. Why he is hanging? We'll hang him or we'll allow him?
Then 27.
No, no. 19,
20.
19. Get that?
Only the advertisement, only.
Public.
Item number 30 and the regional. And so far item number 20 is concerned 29. And response number 5. Now, when I filed this petition, there's the petitioner in August
Just a minute, just a minute.
29.
Who is respondent number 6?
I'm referring for response number 4 and 6.
Ashok Das. You are Ashok Das. And you are
I am
Parvananda Das.
That's what
And you have also filed a separate writ petition.
earlier. My petition filed earlier.
Okay, okay,
Subsequently, this.
okay, okay, okay. Senior, we'll hear him first, then we'll hear him. Yes. Mr. Ahmed, what is your case?
My
Mr. Bhil,
lord,
sorry.
I was, my lord, transferred
Hmm,
on, my lord, 31st of May 2001.
hmm,
Case, my lord, 32.
hmm,
The same post, same category.
hmm.
Therefore, my lord,
With this stipulation?
and therefore my past service shall not be.
Page,
Case, my lord, 32.
32. Okay, done.
And rule 13 of rule 1982.
So, your transfer on 31/5/2001 was with the stipulation that you will not claim seniority over the existing income.
But, my lord, this cannot be covered by the rule 2003
Okay,
because it is itself covered by rule
Okay.
1982.
agreed, Mr. Priyan. This is an order of 2001. From 2001, after you complied with that order, what steps did you take to undo that? Till 2024, for 23 years, what were you doing?
Still, my lord, I am
So
working.
that position cannot be questioned.
therefore, my lord, what your list is concerned,
So that seniority list, we will understand that your seniority in that school will be from 2001.
but, my lord, what rule 2003 is concerned,
Huh.
but
Whatever rule
my
be
transfer
considered,
covered by rule 2008, 1982, which says that seniority shall not be lost on request transfer. And I declared upon my lord this judgment in KP Sudhakaran, says that transfer on the same terms.
yeah, why should we trouble ourselves with judgments? When the facts are speaking for itself.
This is covered.
Mr. Priya, when the fact is speaking for itself, why do you require a judgment? You were transferred in 21 with a particular, 2001 with a particular condition. Have you challenged that condition till date? At any point of time?
But the rule says,
Forget the rule.
rule says I'm
Forget the
entered.
rule.
Rule says I'm entered.
Forget the rule. That condition has to be removed. It is there.
Condition says, my lord, that is impugned, my lord. Impugned. And therefore, the seniority list.
Have you
Yeah.
impugned this 3-5,
And
31-5?
and I am delied upon the seniority list. Kindly have a.
Seniority list is of no consequence. We'll have to take it as 4/6/2021, your 2001, your date of joining. Then next point.
Page, my lord, 41.
41.
Page 41.
That is a seniority list.
My name shown, my lord, under serial number 3
Okay, done.
And-
Accepted.
and transferred on, here, my lord, transferred and joined so and so.
Okay,
And
done.
my submission, my lord, as transfer, on request.
Mr. Bhuya, I am not on that. I am on the condition. With that condition, you proceed. Now take, without removing that condition, you can't
Yeah,
make a
but-
different argument.
Condition is here, my lord.
Then-
I am not denying,
Ah.
but, so far,
And why did you file this writ petition against the orders dated 2/7?
yes. Because one junior already been allowed. To appreciate, my lord, as in subclass, my lord, here. Page 46. Page 46 is in the, my lord. So far seniority is concerned, I am senior. And this junior one has been allowed to look after the class of the school as well as academic side.
Now you come to the affidavit of the government, director.
That is very good. I have not seen.
Okay, fine, no need. We have received it.
And so far, my lord, the affidavit in another petition 6213.
So your challenge is to the two orders by which Ashok Das was given the charge of the post of principal or headmaster, whatever it is.
By overlooking the senior.
And the first was the giving the charge to the inspector, then to the respondent number 6, you. Then you want to hold the charge by reckoning your seniority from 12/12/97. That much only.
And now subsequently, my lord, in the pendings of this case, the respondent number, the petition number item 29, he was not a party, he was not on seat. Now he has been allowed. He is also subject.
Okay. That we'll ask him. Yes, Mr. Hawk. Why are you disturbing Mr. Priya?
My lord,
Hmm?
in fact, my lord, I had joined the school, my lord, on 17/12/1999. But after the, what happened, my lord, at the time of retirement, the under principal, my lord, but he had prepared the input seniority. But the counting charges of the respondent number.
Where is the order now given to you to hold the charge?
That's it. Hey, PTP.
That is academic charge.
Yes, yes, only academic. State matter, yeah. Even 30 matter. I will not even party.
So you are challenging the order of respondent number 6.
As well as seniority.
26 is his principal in charge. Is there an interim order in your case, Mr.? No.
My lord, item number 29, challenging the seniority, which I did approve.
And in fact, my lord, in my case, my lord, even what is for the evidence filed by the director of the data failure. They have clarified their position.
No, where is the order by which you are now continuing for in charge?
That is- Page number, my lord, is my lord, 57.
In your affidavit,
Yes, that page, running page 57.
running page 57. And you have said you have no objection if the court allows this.
Yes.
And my lord, only in some extent, the subject to outcome of the petition, my lord, my revision shall be. But there is no bar. The court already agreed that.
That is interim. We are now finally.
That is
considering.
interim.
Now we are finally considering this again.
And accordingly, my lord, I made representation, that is.
Fine, fine, fine. Anything more?
My lord, kindly come to page 35 of the affidavit in opposition measure filed by the DFO
Hmm.
in my case.
Hmm. Hmm.
Paragraph 5.
Paragraph?
5. Yes, page 35.
Hmm. This is the affidavit by Mr. Priyan,
No matter.
35. Para. Para,
Paragraph
para.
5. That is create the moment of.
That the answering respondent humbly begs to state.
Yes.
Respondent number 5, who received graduate scale with effect from 12/12/97. Okay.
If you don't, it
Okay, that
yes, sir.
is already said.
Moreover,
Now what do you want?
Moreover, kindly come to paragraph 6. That the assent even humbly begs to state that on detection of misconduct for violation of rules starting of the offense of misconduct is satisfied. You cannot of any.
This is something
Yes, yes.
not connected with this issue.
It is. But my seniority is defective. That's all.
Mr. Bhuya, anything more?
Worship, my lord, my extent, my lord.
Now both of them have ganged up against you.
Although they are.
No, he also. He is supporting the
He
petition.
was allowed.
Petition,
Subsequently, my lord,
petition.
during pending of the case. Again,
They have ganged up.
department not bother of its side. The case is pending, they know, even though they whimsically pass the order, sometimes in favor and sometimes in.
That is why, Mr. Priya,
But question.
I am
is
hearing a matter, you are doing a case.
And-
Otherwise, if everybody was doing it perfectly,
And there is interim.
there would have been a lock
who
outside this
say
door.
that there is no part pending of this.
Got it.
case.
I'm sorry. We'll have to direct that your seniority will be from 2001, not before. And then whatever follows will follow.
But we cannot bypass this judgment. When one takes part, the same post, this past service. cannot be-
Mr.
cannot be left out.
Bhuya, there is a judgment of our court also, when there is a specific mention that the transfer is on his own request with loss of
But
seniority.
This judgment.
After judgment.
More weights. But that is administrative order, but the judgment passed by the Supreme Court, having more weights. Here,
No.
element says,
Here the facts are different.
when transferred to the same post, in the same cadre, the transfer will not whip
That
out.
is the problem. In the earlier thing, each school was a cadre. Moving out of that school mean you are going to a different cadre.
But in the same post. And rendering my service without.
Reserve that argument.
any-
Reserve that argument.
Without any disturbance. to any-
Reserve that argument. You will require it subsequently.
So my lord,
It will be good.
whatever order passed, my lord, this may be court, my lord.
Okay, you want me to quote it? I'll quote it.
Because I also relied upon this judgment. Because it's still in the course.
এটা অনুযায়ী এটা মারি গেল ওটা আছে এটা মনে হয় ডিস্ট্রোল দুটাই আরো বিষয় ওটাকে বেশি টেক হয়ে যাবে এটা হলো
Lordship, I may submit one thing more.
just
My lord, my transfer is covered by Rule 13 of 1982 rules, which do not contemplate loss of seniority on request transfer.
of
Because-
rule which rule
Rule 13 of 1982 rules.
but Mr. S. Hop Learned Counsel for the petitioner in WPC number 6213/2024 and Mr. K. Mia Learned Counsel representing the respond number 5 and Mr. D. K. Roy Learned Counsel representing the respond number 6, 4 and 6. Full stop. Raised, full stop. Hearing concluded. Registry to list these matters again on 23/6/2025 for delivery of orders.
Hello.
Time of right.
Yeah.
We have pharmacists, we have given the entrance examination. There is a notification. After the notification, my lordship, we have applied for the exam. We have given the entrance exam, my lordship. After giving the entrance exam, our name came in the newspaper, my lordship. After newspaper came, through the counseling process, we have submitted all our original documents, including mark sheet, the mark sheet now in question. Everything has been checked and verified by the Director of Medical Education, my lordship. After that, my lordship, we got the admission respective government college. In this case, my lordship, petition number 1 got admitted in Silchar Medical College, attached to Institute of Pharmacy, and petition number 2 and 3 got admitted. 2 got admitted in my lordship, SMCS, Assam Medical College, and 3rd got in SMCS. My lordship, after that, my lordship, what happened? Our all the mark sheet and all the relevant document again checked by the respective university college, my lordship, namely Assam Medical College and the Silchar Medical College. After that, lordship, my lordship, we have done our academic career excellent. We have passed all the exam. Then, my lordship, we have passed the first year and second year diploma. Then, my lordship, we have successfully passed out. Then, at the time of the COVID pandemic, my lordship, we have done our internship program, my lordship. After completing the 500 hours of internship training, my lordship, we have applied for the registration certificate. When we applied for the registration certificate, there is no reason order have been provided to us. Then, my lordship, what we have done, we have communication between we have first applied for the Director of Medical Education that our registration has been given by the registration. Then they have forwarded a letter, my lordship. Kindly look into page, my lordship. Here the letter forwarded by my lordship, Director of Medical Education to the register officer, my lordship. Here I have annexed that also. And then also there, my lordship, page number 43.
Page number
43, my lordship. May I proceed, my lordship? Lordship, After that, we have filed a writ petition in honorable court. After that, they have given affidavit in opposition. Learned Register has given that there is a notification 1990 on. According to that notification, I am not qualified because individually I have to pass a subject physics, chemistry, biology. My lordship, my humble, respectful submission is that if there is any defect or eligibility criteria at the time of counseling process, my lordship, that had to rectify. I have not suppressed or any sort of document. All the document I have given them, and they have verified.
Where is your mark sheets?
Mark
Higher
sheet,
secondary.
Yes, my lordship. My lordship, mark sheet page number 14 and 16 for petition number 1, my lordship.
14 and
16. My lordship, kindly see page number 14, annexer 1, my lordship. Here is the petition number 1, my lordship. If you see the mark sheet, my lordship, may I make one more submission, my lordship, here in this for this mark sheet, my lordship.
what is the pass mark? 30.
Pass marks is, my lordship, 30.
And theory?
Out of 100, my lordship.
Theory?
What, my lordship? Sorry, my
Theory, there is any separate pass mark? No.
Yes, my lordship. In physics, I think in theory we have to get 21 marks. But the petition number 1 got 18. But collectively he passed, my lordship.
This became the fourth paper.
Yeah, sorry,
This became the fourth paper.
yes, you have to go. And for the second petitioner, my lordship, kindly see page number
Chemistry.
15. Chemistry, he got 17 out of 21. He needed 21, but collectively he got passed because out of 30 he got 29. Here he got
Physics,
17.
12.
Yes, my lordship. But collectively he also passed. He also passed, my lordship. And petitioner number 3, my lordship, she got grace marks in mathematics, my lordship. Now, my lordship, may I, I have collected 2 judgment of Supreme Court, my lordship. My lordship, may I just summary the judgment and relevant portion, my lordship. In this case, what happened, my lordship? There is a student named Zahid Sheikh, my lordship. He admitted in Ayurvedic college. After taking the admission, my lordship, after 1 year of completing his course, the admission authority said that he did not take the subject English. As per the eligibility criteria, he must should have taken the English subject. And then they have said that after that he has been transferred to another school because that school was derecognized, my lordship. And the second school he got admitted, they said that you are not qualified because you did not take the English subject. What happened he did, he approached the Honorable Madhya Pradesh High Court. At first, Madhya Pradesh Honorable High Court first gave him the interim relief, my lordship. After the interim relief, he was studying there. When the complete case was heard, and the Honorable Madhya Pradesh High Court single base heard that he was not qualified because English was not taken. Then student Zahid Sheikh was again approached the division bench of Madhya Pradesh High Court. Division bench again upheld the single bench. Then what happened? That he approached the Honorable Supreme Court. Honorable Supreme Court, if your lordship kindly see, there is an observation and some remark given by the Honorable Supreme Court. May, lordship kindly see. Sorry.
You read. Be
Okay.
comfortable. Read. Don't break your flow. You're going in a good flow. Keep that up.
Here is my lordship. Then, though the interim order granted by the High Court on 30/10/2012 recorded that the appellant would not be entitled to claim equities, the fact that he was permitted to complete the entire course and had also finished part of his mandatory internship ought not to have been brushed aside lightly. Be it noted that appellant had put in nearly 6 years by then in pursuing DSMS degree course, and the end result of the High Court order was to decimate his entire labor of all those years. An act of the court should ordinarily not prejudice anyone. There is an actus curiae neminem gravity. This is a fundamental principle of justice, but it was disregarded by the High Court while considering the case of the appellant. May I read again, my lordship, here is last. We are of the opinion that this case is a fit case for interference so that the appellant is not left out in the court after completing almost the entire course. Again, my lordship, I have another judgment of Honorable Supreme Court. This one is, my lordship, as resented 2025, 18 marks. Another judgment I have collected, my lordship, judgment 1976. May I just summarize the fact, my lordship? What happened here is an student in Kurshetra University, one LLB student. He did not classes, but he did not fulfill the eligibility criteria as per his class notice. What happened, my lordship, when he has given the entrance, given the examination, my law exam. When he given the sorry, my lordship, given the examination.
Relax, Sensei.
My first time, my lordship.
Relax.
Given the examination, before giving the examination, the principal authority did not say anything about the attendance. After he given the examination, they said that no, you are not qualified because your attendance is less. Then he approached the Honorable Supreme Court. Here is the judgment. Honorable Supreme Court specifically said, if the authorities have said to him before the examination conduct that you are not qualified because attendance is less, after giving the examination, authorities cannot say that you are not eligible because he has given the examination. And here is the observation by Justice Honorable Justice Fazal. This is judgment given by A.S.R. Khanna, P.N. Bhagavati, and S. Mortaza. May I read, my lordship?
Yes.
What effects to have in a clear case of refusal of admission of the appellant or the cancellation of his candidature at the proper time has been completely bungled and destroyed by the inherent inconsistency and seemingly contradictory stand taken by the respondent and lack of proper vigilance on the part of the head of the Department of Law. The fact of the present case lie within a very narrow compass of only two short points of law have been raised before by the Mr. Kapil Sibal, learned counsel for the appellant. In this case also, Supreme Court had clarified after taking
Got your point. Got your point. Anything more?
My lordship, may I just say that they belongs to very poor family, my lordship. They are ST category. They have done everything. They have completed the course, my lordship. They have been waiting for the certificate for 3 years, my lordship. If they get the registration, at least, my lordship, they can be same employed. They are in the marriageable age group. They are having financial hardship, my lordship. My lordship, it is the honorable court have the discretion, my lordship, save their livelihood, my lordship. And they can at least, they can be self-employed, my lordship.
Okay.
That is my humble submission.
Okay.
for your lordship.
Good. How long have you been in practice?
My 6 month, my lord.
Very good. Keep it up. Yes, Mr. Leave everything aside. Leave his arguments also. Come to page 43.
43. Letter to director.
After this, what is there? We are allowing. You give the
So far as
unique case. We'll make it that this is not a precedent.
At that part, my lord, so far as the judgment that has been placed.
That we are not going.
It is under Article 142.
We are
That
not
can-
going into that. We don't have that power. But here, you with your open eyes permitted them to participate in the course. Once you have permitted them, they have cleared, you cannot.
In fact, my lord, in the advertisement also, that we have next, my lord.
Advertisement also, the prescription is there.
It
That-
says, my lord, physics, chemistry, biology.
We have
all
got it,
maths.
page 18.
Yes, page 22. So you will see the eligibility criteria, page 23, part of the advertisement.
No, this is BSc nursing.
No, 23. Diploma in pharmacy. If one, my lord, candidate must have passed the higher secondary examination 10+2 or equivalent examination in physics, chemistry, and biology or mathematics from a recognized board counselor.
What is this then, page 18? Oh, this is BSc nursing. Sorry. So here, the individual passing is not there.
No, it says, my lord, physics, chemistry, and biology or mathematics. So physics, chemistry, or biology or mathematics.
Anything
3, yes.
that he has passed, that means one will become fourth paper.
No, they will have to have this
No,
particular.
or
combination.
equivalent examination with physics, chemistry, biology, and or mathematics.
Pass.
So biology and or mathematics.
Yes.
He has everything. All the three he has.
So whether the mark
You don't say yes, should have passed.
is passed.
You say pass the higher secondary examination.
Procedural, will see page 14, my lord.
I'll tell you my thing. I had physics, I had chemistry, I had biology, botany, zoology, biology, and mathematics. I passed my higher secondary, but I plugged my maths paper.
Same here.
That-
It became my fourth paper. But if you ask me, I passed my higher secondary with maths also.
Yes.
21 is required, I suppose. I think I got 18. I was so good in mathematics, they couldn't understand my answers.
I was also not good in mathematics, my lordship.
So, Mr. Gogoi, I think we'll have to permit. We'll direct. This is the qualification.
Yes. This is the, not the notification, this is the advertisement. Sorry.
This is the advertisement. Come to the educational qualification.
At page 23, the eligibility criteria has been given. This is my.
Candidate must have passed higher secondary 10+2 or equivalent examination with physics, chemistry or biology and or mathematics from a recognized board, council, university. That much only.
Yes. Now, on page 14, Lordship, you will see whether the petitioner has one petitioner, he failed in physics. So
No.
physics,
That is
chemistry will
where,
have to be
that is where your director's page
clear.
43 letter would
There
come
was
in.
clarification.
Do you get my point?
Since there is a clarification from the highest state authority. there is a
It's
direct-
very rare that I hear somebody for such long. But I like the flow
Yes,
with this. And Mr. Counsel, don't laugh. Today, you have set a mark, benchmark. You should not fall below that. Do you get my point?
Yes.
Just
My
keep the hard
My
work.
lordship, at the orientation program, your lordship said that if any new advocate are in front of me, you said that I will highly appreciate. That's why my lordship, I prepared the assessment by myself and this also. my
The
lordship.
person is sitting there, Mr. Bonta, the culprit behind that. Writ petition allowed. Your name?
Amin, my lordship.
R. Amin
Yes, my lordship.
and Mr. Gogoi. Lemma Didi.
That affidavit, my lord, two para Lordship may kindly consider, my lord. Just I leave it to your Lordship. 4 and 7. Of the ballot council.
It was also handicap Yes, Mr. Gogoi.
Lordship will just refer to that, my lord. The ground is, my lord, they have not passed out in this. That for my sake, my lord.
No. Para?
Para 4 and 7.
We have seen that. Okay. Writ petition allowed.
That
You'll
is
get
not-
the order by
You
Friday.
get, my lord, that it will not be a precedent. Otherwise, my lord, there are lots of pharmacy institutions now. They will start taking.
This is unique because here there is a I'll bring that
In fact, the
director's.
director's letter is the main.
Highly, so highly appreciate. Wait.
Yes.
Yes, Lordship, in page 29, we have mentioned that earlier judgment result. Page 29, Lordship, we have sent it to the Accountant General for 29.
Who is creating the problem now?
Accountant.
Yes.
The art of the appeal, mostly difficult is where problem is actually appear. So its contention is that there is a notification of the government that bars taking into consideration that initial 6 years of service.
That is gone by the.
There is a judgment, but we have sought for a clarification from.
Why have you not implemented that?
Yes, I'm coming to.
Why he is so unique?
No, I'm coming to that
Oh.
one. What happened after the judgment, we had written to the Pension and Public Grievances Department, who had issued the OM, seeking clarification whether the benefit can be granted to all criminally situated persons. They said that.
Is the order of Sangeeta Roy limited to the petitioners therein?
No, we are just the implementation.
And
Your Lordship is
can I
talking-
ask for can I call for records that beyond Sangeeta Roy, whether 6 months have been condoned by you?
Beyond,
Sangeeta Roy petitioners, you have, or make a statement that beyond 6 years, you have not condoned in any case other than the petitioners in Sangeeta Roy.
my comment is, whoever had got an order from the court.
Other than that, you have not done.
To my knowledge.
Are you true? Are you sure?
To my knowledge, my lord,
No.
my knowledge, No other persons have been giving.
Okay, we'll find that out. We'll find that out.
That information has been.
That is the law now.
Yes, yes.
That is the law.
We are not opposed to giving that benefit, my lord. The problem is the clarification from the.
I'm sorry, there is no requirement for a clarification.
The clarification has been provided by the Pension and Public Grievances Department to us. We are just the implementing authority.
Have the Pension and Public Grievances Department after this order said don't give?
They said that this
Huh?
judgment would be.
Page
applied by-
45, my lord, they said that the earlier notification was not retrospective. Page 45.
That is not the case, my lord. The clarification that we got from the.
They themselves has-
department
Where is that
Page
clarification? Give me.
45, my lord.
Why should
Okay,
this
Bella.
pensioners start coming to the court?
He has given the pension, man. He is receiving the pension.
You are receiving pensions. You are getting pension.
Pension, my lord, 6 years deducted, my lord,
The benefit is.
from my net qualifications.
Where is that pension and public grievances thing? I want it.
We'll take it after 10 minutes, I'm giving you.
Wait, we'll see.
That's it.
I have not received the instruction regarding sufficient allowance. He has been terminated also.
What? See, he has not presented a challenge. Without payment of subsistence allowance, continuation of department proceeding, one ground to set it aside.
I will have the instruction when it will be paid, let it be taken up next week, Friday next week.
Heard, Mr. Your name?
P. Katonia.
P. Hatonia, Learned Counsel for the petitioner, and Mr. P. Gugu, Learned Additional Advocate General appearing for the respondents. And Mr. Also heard Mr. B. Sharma, Learned Standing Counsel appearing for the respondent number 5, Accountant General bracket A&E. Mr. Gugu submits that the grievance of the petitioner of that he has not been released his subsistence allowance for the period with effect from November 23 till November 2024 is being considered by the respondent authorities, and he would place before this court on the next date of listing the outcome of the next date, the period within which such benefit, if due to the petitioner, shall be released to him. Registered to list this matter again on Monday, 16, 17,
18.
18.
Physiology.
That is enough.
Produced the order dated 19/3/25. Is the last order. It's a very unfortunate development, my lord. His retirement benefit has not been paid, man. It is, contempt has been filed in 2013, my lord. Since then, it has been, they are,
Madam, the violation is of the order dated 13/8/23.
13, my lord.
13/8/23.
At
Yes,
13,
madam.
13/8/13.
The respondent number 1 of the contempt of the instant contempt case, he has been transferred your lordship. That is the manager of Psychota PSA.
Okay.
And it is and your lordship, the managing director of ATCL, he is also
Who is there now?
transferred.
Where is this office?
His office is in Houseway, your.
Elsewhere.
Yes, your lordship.
Still there is 45 minutes. Ask them to come here. We'll see. We'll deal with them directly.
Yes,
A boy, man is not getting his, we have passed the direction. Have you taken up this on appeal?
We have communicated them.
Have you taken this order on appeal? No. Then why is it not been implemented from 2013?
The former MD.
Are you the counsel engaged by the
I'm
respondents?
probably that.
Topondas. Ask him to be here. Call him. Let him come. Ask Mr. Das to come. Or we are asking the respondents to be here. 2013, this order. Are you also not moved by the fact that the High Court's order is not complied from 2013. Get Mr. Das immediately. Or we'll sit here till 6 o'clock. We will have your director here. I want this order complied with. Get calling.
That's it. The authority has already complied with order.
Your name?
PK Gogoi.
Mr. PK Gogoi, Learned Counsel for the respondent, submits that.
But I'm for the petitioner.
Oh, sorry. For the petitioner, submits that. The order dated
19/5/2020.
19/5/2023, passed by this court in WPC number 2505/2023 has since been complied with. Accordingly, he submits that the present contempt petition be closed. Full stop. Prayer accepted in view of the compliance of the directions passed by passed, comma. The present contempt petition stands closed.
Pleasure.
Yeah, please, Lord. Also, kindly see it, Ravazima Court, order, 21/11/2024.
Hey, please.
Hmm.
I'm appearing under response number 1 and 2 minor.
Hmm.
They are a private limited company.
Hmm.
Kindly see the pair of minor, page number 21 minor. This case is not maintainable matter. Kindly see the pair of the petition minor, 21 minor, page number. They are claiming some profit, salarial.
Yes, Mr. Yes, sir.
But we were appointed, we were engaged by the respondents, 1 and 2. They deducted our portion of
No,
salary.
no, tell me first thing. Is this a state within the meaning of Article 12? Or another authority meaning of Article 226?
My lord,
This is a private limited
Yes.
company.
my lord, in this regard, my lord, if they file affidavit, my lord, I
No,
can address.
why? You satisfy me first. How is this writ maintainable? You are asking for a direction upon respond number 1 and 2.
Yes.
For release of your 15-day salary and the
Salary.
Yes.
provident fund.
Yes, my lord.
I'm sorry. Want to prepare? Take an adjournment?
Yes.
But otherwise, I'm dismissing this.
Take up another day.
On the prayer of Mr. M.K. Mr. Learned Counsel for the petitioner, registry to list this matter on 21/7/2025 for further consideration.
Okay.
Huh?
Please-
21/7. You check up that.
Mr. Says only the petitioner, that is our problem. We have to implement, we do not have any problem in giving the benefit. This is the problem. We have sought for a clarification and this was given by the Commission Secretary to the Government of Assam Public Pension and Public Grievances Department. We are ready to give it. No problem with that.
Who is appearing for the government? I want once this court has passed an order, how can you limit it to persons who will only appear this court and take a similar order? How can you do that? Get your instructions. Tomorrow we are taking up, day after tomorrow we are taking the matter. Give him a copy. Explain the position to him.
Our pension, it pays 29. This is the pension papers. Remarks, the initial 6 years of master certificate is not deducted in compliance of the honorable court. That they are not doing.
They have their own notification, public pension and public grievances department. Where in 2010 itself, they had clarified the position that 2009 notification on which these 6 years tenure is counted, it will not be retrospective, it will be prospective. It is their own office memorandum that I have annexed.
So you have brought this case before us.
My lord,
If we can clarify the position, it will help a lot of people.
lot of,
So let us do that. We'll come back and resolve your issue.
my lord.
As prayed for by the Illinois Council for the parties, registry to list this matter again on Monday. No, I'm giving you time till Tuesday, 17. 17/6/20.
7.
You get your clarification. No. You explain that position to me.
Obliged.
Deeply obliged.
I may be permitted to place certain date before your lordship. Item number 30, lordship, I may be permitted to place some dates before your lordship.
Huh?
I may be permitted to place some dates before your lordship.
No, whether the order has been complied with.
Nothing, lordship.
Where is
No
that order?
response- No response from the bill. Lordship will come to page number 37, my lord. Paragraph 90.
Paragraph?
19, your lordship, page 37, paragraph 9.
Yes, what have you done?
My lord, instruction is awaited, my lord,
Why?
sometime is required, my lord.
This order was of
Lordship,
23.
lordship.
My lord, I am appearing on behalf of SMT 64.
Whoever,
Respondent number
whoever,
1, my lord.
whoever.
Sometime may be granted.
Time. I'm here. I'm here. 5.
Unless my lord.
23, the order is not being, have you filed an appeal?
No appeal.
No, no review.
No appeal, no appeal, no review, lordship.
Can't help.
The last order is of 8/1/2025.
On the prayer of Mr. Sharma, Learned Counsel appearing for the respondents, registry to list this matter again on 19/6/2025, on which date he shall apprise with regard to the status of compliance of the directions passed by this court, wide the order dated 12/4/2023 in WPC number
7026 of 2020.
double
7026 of 2020.
7026 of 2023. Registry to list this matter again on 19th. What idea? Only a simple direction you're not complying with. What would be the fate? 2013 orders are not being complied with. That is again by a private firm. 23, you are just sleeping over the matter. Mr. Sharma, take personal interest. Bipul Deka.
Yeah, please, your lordships.
Hmm.
RB Bora. She's not worried with the lordships.
Prayer is made on behalf of Mr. R.B. Bora for an adjournment in the. Mr. Mr.
My lord will just for a moment, my lord will take up page 16.
Complied with?
Not compliant, my lord. My lord will just take page 15 for a moment. What was the
See,
direction?
an advocate, a prayer is made that she is not keeping well. So we'll take it up after 2 days. It
My
can
lord,
wait.
My lord, my lord. My
Oh,
lord,
it
we
cannot
can
wait.
Next week, my lord. Adjourn it.
Okay, argue. What is it?
My lord, page 16. Because, my lord, this was an order, my lord, passed on 21/8/2023 order, my lord. Page 11, if my lord will see the direction, the petitioner shall produce a certified copy of this order before the principal secretary BTC. It is provided that on receipt of the certified copy of this order, the secretary shall reconstitute the committee for compassionate appointment with an outer period of 2 months from the date of receipt of the certified copy of this order, and to take up the candidature of the petitioner in terms of the said OM dated 1/6/15 and specifically consider clause 15/14 thereof. These 2 months have expired long back, my lord. It's a contempt, prima facie, my lord, on the face of the record, it's a contempt.
Okay. What do you want me to do? Drop contempt against them?
And my lord, you see the last.
You want to drop
previous
contempt?
orders, my lord, they have assured
Hmm.
that the meetings would be
I'm
conducted.
sorry, this man is no longer there, I suppose. Akashdeep.
He is there.
He's there. Akashdeep is there. Okay.
He is there.
Have you filed your affidavit here?
No, Lordship.
Why? Why?
The
So we'll ask the the respondent to be here.
As Bora is here,
And
it is a
appointment.
pledge, Lordship.
Huh?
Kindly pass over for the time being. As Bora.
As Bora
He's
is there,
also there.
call him. When did your father die?
My lord. 2002, my lord.
2002. Let him come. There is no contempt because of Debabrata Tiwari. There is no contempt committed because of Debabrata Tiwari, you're not entitled to a consideration. We'll pass that order.
So it has not been challenged, this order.
But need not be. It's between me. They are placing Debabrata Tiwari. I'll say that will be wholly feel. That is the decision, latest decision of the Supreme Court. In terms thereof, they need not consider your case. Be that as it may. Be that as it may, direction has to be valid. Because of Debabrata, it is not valid.
When the contempt jurisdiction.
I'm sorry, I'm going to pass that order.
Opportunity to.
Because if you are not interested when a council is making a submission
I am
that she is
interested, my
not
lord.
keeping well, you are not even give her an accommodation for a day.
I can give that, my
Then
lord.
why were you making your submissions then?
Wanted a fixed date, my lord.
Have that camaraderie in the bar.
Also the suffering from this petition.
I know that from 23 you are suffering.
That is what.
Mr. Gupta, you are suffering from 23, not from today. When a council, if any other ground, I would not have saying that
But I
she is
just
not
want-
keeping well.
State, my lord, can give otherwise. I have no objection.
Submission is made in the bar on behalf of Ms. R.B. Bora that she is in for an accommodation in the matter today on the ground that she is indisposed. Full stop. Prayer for accommodation. Full stop. In view of the above, registry to list this matter again on 18/7/2025. On the next date of listing, the Learned Council for the respondent shall place before this court the status of compliance of the directions passed by this court, wide order dated 21/8/23 in WPC number 671322. Make a note of this.
Much obliged.
Yes, what is the
They have to pass a follow-up compliance order, my lord, with regard to, my lord, provincialization of the register of the husband of the lead prisoner, my lord. That has not been done.
you are arguing for which matter? Appearing for which matter? 40.
Is for
40. 40.
41. Sorry, lord, left.
This is the lordship will dismiss this case, my lord, citing Debabrata Tiwari, my lord, that the compassion appointment. Now, my lord, when this case was dismissed, later on we will come to learn, my lord, because of the pendency of the case, my lord, the matter was under consideration for the DLC, my lord. Now, because of this order, my lord.
Show me what is that. That is a consequence.
No, my lord.
What is the error?
My lord, not the error, my lord, because this document we could.
If there is no error, we are not in
Number one.
review.
No, this document, we are not in a position to bring on record at that point of time. Lordship, see, my lord, 3/11/2023.
I'm sorry, that is not the reason. Your reason for dismissal is
My lord.
the time lapse
Sure, my lord.
from the death
No, my
of
lord.
the government servant till.
My lord, lordship will see, my lord, in this particular, my lord, consideration, my lord, people who had died in 2004, my lord.
Be the negative equality, I'm
They-
not coming in.
And my lord, but there are other, my lord,
Mr. Doctor, this is a frivolous review
my
petition.
lord, there are,
This is a frivolous review petition which will entail cost.
well, in the meanwhile, my lord, there has been, my lord, several decisions of this on the court.
I am not, you go upon appeal.
Inside that, because, my lord,
You can go upon appeal, but this is not a review. This is frivolous.
my lord, because this,
This is trying to take,
my lord, otherwise, my
make a
lord,
bit.
others
and
are.
that this will entail cost now. I let off this matter at that point of time, the council, I let him off. But now I think we'll have to.
And that is I'll withdraw it, because this people.
Better. Mr. M. Dr. Learned Counsel for the petitioner, after attempting to argue the matter at some length, submits on instructions that he be permitted to withdraw the review petition. Also, prayer is not objected to by the Learned Counsel for the appearing for the respondents. Also, in view of the above, the review petition stands dismissed on withdrawal.
43 and 46 in that one.
40,
43 and 46
43.
And 40.
We are now in item number 40.
40.
43, 46. Same over. Do we have still any? Yes, complied with,
Not complied with.
not complied. Yes, Mr. Saul.
Hearing was held on 29/4/2025. Now
Wait,
verification
wait,
process
wait,
is
wait,
going
wait.
on, my lord.
Oh, that case.
Yes, Lordship.
Ah,
They have to pass the consequential order.
yes, 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 yes.
What they
No
have-
appeal against this.
No appeal.
Oh,
What they have done, my lord.
Instruction, my lord,
What they have done.
hearing has already been completed,
Hearing,
already held, my lord, and my lord, now verification process of the.
how long will it take? 1 week, 10 days? This order is of 24, 1 year nearly.
So sometime may be granted.
Why? We had time from 27/6. Okay, you had time from 1/7 till now. So I'll give you time till 23. Get the compliance order.
That
Mr.
case is
Sharma,
Filed on, my lord, filed, my lord, on 2025, man.
hurry, contempt is filed.
Yes, yes.
You want to wait till the contempt is filed to
No, no.
move? This is director,
secondary.
secondary. Or next date she'll be here. Can't help it. This cannot be tolerated.
Unless, my lord, last
Mr.
time-
U. Sharma, Learned Counsel for the for the respondent submits that he would complete his instructions in the matter. He submits that the respondents are processing the matter for compliance of the directions passed by this court via the order dated 27/6/24 in WPC number,
In review petition number
in review
106.
petition number 106/2021. Also, he submits that the compliance report in the matter would be furnished to this court on the next date of listing. Registry to list this matter again on
After vacation, man.
16/7/2025. I said compliance report.
Lovely.
1 year you don't require, Mr. Sharma. Yes. Mr. Monta, what are you waiting for? The evening hours? No, if you are privileged by sitting there, I have nothing to do, nothing to say. Yes. What is your, which is your matter? Oh, that supply matters. Okay. We are coming to. Oh, you don't have anything.
Whatever I have filed this review petition.
That money you have got,
Money, principal amount I got, Lordship, but
Okay.
rest part has not been.
then we'll consider this after the vacations. Nothing urgency now.
Lordship,
As agreed to by the Learned Counsel for the parties, registered to list this matters after the ensuing vacations.
Obliged, Lordship, keep level. Obliged.
Seen the office note dated 16/5/2025. Service of notice upon respondent number 3, 4, and 5 have been deemed to be complete. Also, anybody appearing? 6. Okay.
Time for 1 and 2.
Mr. I. Bothaku, Learned Counsel, appears for the respondent number 1, while Miss so-and-so appears for the respondent number 6. Full stop. Yes, madam, what is your case?
Lordship can fix the admission hearing, Lordship, and non-regularization of the post, Lordship. He is appointed on he was appointed on 14/8/1998, Lordship, as a master roll worker. Juniors are promoted and regularized their service, Lordship. I have already retired, Lordship.
After vacation, we'll dismiss. After vacation, we'll dismiss. Registry as agreed to by the learning council. Pauline, ito ekini likhla na? Ekini? Push up. Accordingly, all the party respondents are represented. Push up. Registry to list this matter again after the ensuing vacations for admission hearing. Yes. Yes, Mr. Tapan. Yes.
Lordship,
Uh,
actually, he was after superannuated. His pension up to 58 years already have been paid by, he has filed 2 contempt petitions. In the first contempt petition, we have already informed the court that we have already made the pension 8 lakhs. That is.
where is that information in this court? Before this court? Have you filed that information before this court?
Lordship, probably they have filed their petition, I see, Lordship. Actually, out of station, I have just reached. If telephone me, then I am coming to the court.
But from 2013, madam says these orders are not complied with.
That is the disputed fact, Lordship.
No, not.
There cannot be any dispute.
Lordship.
It may be 10 rupees.
I am.
Mr. Das, you had quantified 10 rupees paid.
Right.
She may claim 100. That is a different thing altogether. But
And moreover, Lordship, I have written a letter to the, after passing of the last order, I have written a letter to the managing director and requesting him to, if any outstanding is pending, it has to be paid to the petitioner. So that letter is with me, Lordship.
but that what will I do?
No, because my part is over.
Your part is over means?
That means I have already communicated the order of the honorable court last time.
Oh,
Because
that means you are not having any other
No,
responsibility.
no.
You ask your director to be here.
Lordship,
Whoever, managing director to be
now,
here.
Lordship, at least 2 weeks time may be granted to me. At least 2 weeks time may be granted.
Your managing director is not even responding to
instruction is
you.
awaited, Lordship.
Mr. Das, your managing director is not responding to you. What
Managing director is
instruction?
Not a party, they have not implemented him now.
Who is the party?
Rakesh Agarwal is presently managing director. They are not implementing the
Okay,
party.
fine, no need. How long, how many will they
All of-
implement? You get your instructions.
all of them. 2 weeks, I will
No,
make the-
not 2 weeks. We'll have this matter on 23rd. I want the instructions
Oh,
on
okay,
23rd.
I'll definitely take the. instruction.
Mr. T. Das, Learned Counsel, representing the respondent, submits that he would place before this court the status of compliance of the directions passed by this court, wide order dated 13/8/2013 in WPC number 1104/2013. Also, in the event the said information is not placed before this court on the next date of listing, this court would consider personal appearance of the present incumbent in the post of managing director, inasmuch as it is seen that the directions passed by this court way back in the year 2013 have been contended to have remained unimplemented till date.
Obliged.
Mr. Das, use your good office.
Lordship. No, I have already communicated.
You use, if you can't, your persons are not responding, just tell us, we know how to get them.
Oh, Lordship. Definitely.
Madam, wait till for a date.
Obliged.
Obliged.
Lordship, service is still awaited. Yes. Yes. We don't have any maybe process reports available to us.
Await service of notice upon the respondent number. Sole respondent. Sole respondent
Yes, sir.
for further 3 more weeks.
Any of this.
Lordship, the petitioners are lecturers in polytechnics
We are the founding lecturers. The polytechnics was started in 2020. We were appointed in 2021 pursuant to an advertisement and a.
What is it for today?
Today, Lordship, actually, Lordship, what happened is when the matter was filed, we were continuing to work, not disturbed, so it was subject to.
Today you are
outcome.
not working.
We're working. We are very much, we were in total 46 of us. Right now, at least 11 of us are working.
Others are.
Yeah, and 11 of us is who's,
So
preferred-
today, what order do you want?
Lordship, not to be released. Pending our writ petition not to be released.
That
Lordship-
after, because I was a party to a proceeding, similar proceeding before the high in the division bench.
Yes, yes.
I had upheld that
Lordship,
selection.
That's guest faculty. Now, Lordship, may give me a moment. Basically, Lordship, we are not guest faculties. We were appointed.
Is your also post also within the purview of the selection process that is now going on?
No, that is my submission.
Yes.
That is my submission that we are pursuing to a 2023 advertisement, which we've challenged.
That is that walk-in advertisement,
Lordship,
walk-in interview.
walking, no, not walking. It's a interview, it's a written test. There was a advertisement.
Where is that? Where is that? Where is
Yes,
that?
Lordship,
Yes, Mr. Gogoi, what is it?
Lordships, that post which were occupied by the petitioners also. They are also the recent advertisement there, this poster they are also.
After in persons to my Lord Justice Jami's order.
That's all. Then Lordship, the pursuant to the earlier judgment, I will make kindly to the repetition pair.
Lordship, may I give you a list of dates? Just 5 dates which.
Madam, just I only want to see whether there is an urgency to hear the matter today.
Lordship, on the last occasion,
This advertisement dated 21/2/23 is no longer there.
It is already
Gone.
gone, Lordship. So,
yes, that.
It's a
Lordship,
logical
there is an
conclusion.
order saying subject to outcome. We were working, which is why we didn't press. There's an order of this honorable court saying regular appointment may go ahead, subject to outcome. What is our case in the writ petition?
Writ in the nature of matter should not be so that.
We are-
I
we
must
say-
have the post of-
We say we are regular.
Madam,
employees.
just a second.
Right.
Wherein the present is being appointed when. So your grievance is qua, the advertisement dated 21/2/20.
Yes, Your
2000.
Lordship. We-
That advertisement is already set aside,
Yes, Your Lordship.
finished.
No, not set aside. It's gone. through.
21/2/23 is set aside.
21,
It's complete.
23 Lordship.
It's fulfilled.
Session was already completed, Lordship.
Completed. 80
Already
posts
one
have
part
been
was,
appointed.
one part was set aside, one part was completed, Lordship. Non-technical.
This is what, not the polytechnics.
Polytechnics.
These are polytechnics. Polytechnics was remanded back.
Polytechnics was remanded back, Lordship. That was completed, Lordship.
Lordship, we
That was completed.
Completed. That was completed, Lordship. As on
Lordship,
that, Lordship, the
there was
registration
initially
is in
2000
fact.
Lordship may take a, there was initially a 2017 advertisement. That 17 advertisement were challenged by guest faculty members who were already engaged. So they
This is 2/7/24 is my Lord Justice Jami's order,
27,
right?
no. Yes, this is a news order. Yes, 27 with liberty to, yes, Your Lordship, you're right. Lordship, may I just take you back? 2017 is the first advertisement, which is 113 posts plus 86 posts. Thereafter, this gets challenged by guest faculty. We are not concerned here. By guest faculty. Meanwhile, there's another advertisement, 21/2/23, where we come in. This is the post that we were appointed before in 2021. We say in challenging this advertisement, we say that you've given us at a cabinet level decision, ex post facto approval, and you inducted us into the regular cadre. Therefore, we are no longer ad hoc. Therefore, the post we occupy must not be open for regular appointment. To which there was a subject to outcome. This 80 posts has been filled up and they have still not disturbed us. Thereafter, Your Lordship, this 2017 advertisement is set aside by 2/7/24. And then now the new advertisement is coming, against which they want to release us and fill somebody else.
This 30/12/24.
Yes.
Make
And
a
Lordship
challenge to that.
Lordship may kindly take a look at the last order. In fact,
8 of us were released.
Because the first order that was passed by this court says subject to the outcome
Yes.
of the
Yes,
recruitment.
yes.
That is gone. That recruitment is gone. 21 to 23, it is
Yes, and
complete.
it didn't disturb us. We continued.
Then what more is left here?
No, Lordship, our writ petition is pending. The basic issue is whether we are regular or ad hoc.
Now,
Lordship,
Lordship,
may
now,
kindly take a look at, Lordship, 1 minute, 1 minute. Lordship, may take a look at 17-12-24 order of this writ petition.
This-
17-12-24. What had happened, your Lordship, is passed in an IA 3712. What's it? It's a copy, isn't it? 3712 of 2024.
3712.
Lordship, may I explain? It was subject to outcome. Then in December, 8 of them were released, which is why prompted us to file an application.
1712.
17-12-24.
Hmm.
So we came here by way of an IA seeking protection that please don't release us. They seek instructions, and your Lordship may kindly take a look at the instruction paragraph 3. This is what I'm asking for, nothing more, nothing less. It is their instruction. Lordship has 17-12-24. The relevant portion is extracted here below, and it's paragraph 3. Lordship has that?
Yeah.
Paragraph 3, none of the petitioner's name is reflected in the above list. As such, no appointment has been made by way of regular appointment process in the posts held by the petitioner under 3F. This is their stand. So we again didn't press it. So until Lordship may hear our petition, till this disposal of the petition, you may give a date not next week, the week after. And until then, they must not release us. And there's enough vacant posts, which is why we are still working.
Okay. Yes, Mr.
I will clarify it. Lordship, may kindly peruse that particular instruction. What is this, Lordship?
Hmm.
First, my Lord, may kindly peruse paragraph 1, Lordship.
In compliance of the Honorable High Court order.
In that particular advertisement, Lordship, their post was not there, Lordship, and they also participated, Lordship. So yes, because their posts are not there in that particular advertisement, they were not released, Lordship. This is the instruction, Lordship.
So you mean to say that now that in the second advertisement of 30,
It's included, Lordship.
3012,
Lordship, this is included, Lordship.
and have they participated in
That
this?
they have participated, this advertisement was not put to silence before this honorable court. When some of the petitioners silenced before this honorable court rejected their claim. Even that was, Lordship, before the honorable division bench also. Division bench also negated their claim, Lordship. And it is almost the last stage of
These are the posts in various polytechnics.
Lordship.
3F, initial appointment is under 3F. They're not gas package.
Same thing, adopt.
It's different.
Where
because-
law is well settled.
What?
Lordship.
3F?
Yes.
Law is well settled.
Madam,
Yes.
Patrick, if it is 3F, then it is more the important that it should be immediately done away with.
Yes, Your
Because 3F is 4 months only.
That is my submission, Your Lordship.
You're done away with.
Absolutely. It's illegal to continue 3F beyond 4 years, maximum 1 year.
No, 4 months, 1 year.
Oh, sorry, 4 months.
So
1 year.
what
Which
right
is-
do you have to continue this?
So our submission is that I was appointed in February 21 after 3F because there were no posts. So 3F is also a situation where there are not posts and you have to immediately appoint somebody and engage their services.
So you were appointed against non-existent posts.
3F.
3, what is that 3F?
3F is
3F will come in only when, madam.
outside permanent post. That's
No.
3F.
No, I'm sorry.
Lordship may take a look at 3F.
Yes. 3F, Assam Services Money. Take the limitation functions. It cannot be outside the purview. That is why when the cabinet had approved
Yes.
the conversion of contractual appointment, they said not 3F, but the benefits of 3F,
Yes.
The line of.
line of 3F. Now come to this will clarify the issue now.
Yes.
We can
3F.
dispose of the writ petition itself.
Lordship 3F.
Madam, just satisfy me on this.
Yes. Let me go through CF. Lordship at
Okay.
3F. Lordship at 3F. When an appointment is to be
Limitation, page 119.
95 is this the book?
The books are different. You can continue. 3F, okay. Okay.
when an appointment is to be made by direct recruitment to a temporary post created in a service. If it is necessary in public interest that the appointment should be made immediately and reference to the commission would cause delay, provided if the post has been sanctioned for or is likely to last more than 4 months, the commission shall as soon as possible be consulted. So it is a temporary post and not a post sanctioned for.
Madam,
And Lordship, I rely on your Lordship's
Madam.
order in Asim Gogoi. to
Madam,
say-
the post in this service is to be filled up by the APS,
Yes, your Lordship. Yes,
right?
your Lordship.
If you go to Article 320,
Yes.
3, I suppose, that is envisages the power to the governor to lay down a rule enumerating the factors
Yes.
wherein the APSC is not to be
Correct.
concerned.
Correct.
This rule is to that effect only.
Yes.
It is under that exception clause that this is made. If you can come to the beginning of that rule. In exercise of powers
Yes.
conferred under clause 3 of Article 320 and in superstition of all previous orders on the is pleased to make the following regulation regarding services and posts in connection with specifying the matters in which it shall not be necessary for the applicable commission to be consulted. So, if you have been appointed against a post which is not created,
A temporary post. It's a post,
You
not
said-
sanctioned post.
you
That is
say it was
yes.
not created.
It's a temporary post. After that, in March, there is a sanctioned post of 260.
260.
260.
Have you been accommodated against that?
That is my submission. That is the writ petition.
Then, madam, you will have to appear before the APSC for regularization.
Lordship, at a
If it
cabinet-
is 3F, you
No,
don't
no.
have a right for regularization.
Lordship, at pursuant to a cabinet decision, they have come up with a notification. Lordship knows 4 months.
Whatever notification, let it be even the cabinet. If the cabinet has taken a decision to regularize your services, nothing like it. We'll
It
keep
is
our
there.
hands off.
That is my submission.
Where is it? Show
Lordship,
me.
that is page. Lordship has the IA or the writ petition.
Anything, whichever you want me to do.
Lordship, then may I take a look at the IA, page 31, whichever.
Page 712, yes.
Page
Page
31,
31. Okay. Yes.
15, 12, 21.
Oh.
Office of the Order of the Governor.
Hmm.
In the interest of public service and in pursuance of this department notification dated 22/2/21 and cabinet decision held on 24/11/21, the governor is pleased to approve the ex post facto appointment of the following lecturers of 5 new polytechnic at Chirang, Morrigaon, etc., appointed under 3F of so and so with effect from the date of joining on usual pay and allowance as per admissible. They do this and Lordship may.
So you
also-
mean to say that this is your regularization in
Yes.
service?
Lordship, I look at page 43.
Madam, are you sure that this is your regularization in
Yes,
service?
yes, page 43. And I'll show you why.
Hmm.
Page 43.
43, okay. Cabinet decision is there?
No, cabinet decision is not shared with us. We don't have copy of the cabinet.
You had the cabinet decision in the last other file. You could have brought it in that division matter
No,
matters.
Lordship, that's a different cabinet decision.
Oh, this
That's
is different.
Decision of guest faculties being
Okay,
made 3F.
Okay, what is it? What is it here?
This I don't know, Lordship. This is a cabinet decision of ex post facto approving our appointment. Lordship, now page 43. While granting approval ex post facto to our appointment on usual pay and salary allowances, on the same day they come up with this office memorandum. And what does this office memorandum say? Education Department, Government of Assam is pleased to notify that any government employee who has been selected and appointed for any state job, government job, under the Education Department, both teaching and non-teaching, is not allowed to apply for any other government state level government job in the same position grade up to a maximum period of 3 years.
I think we have dealt with this argument of my senior Mr. Goswami sir and KP Pathak sir.
Yes. No, Lordship, but we are in different, 3F has a different.
Come to page 45. What is this?
This is my prayer to say there is enough vacancy. By cabinet position, you are converting guests to 3F. So you're continuing ad hocism.
Madam, this is not 3F. This is in principles outlined in regulation 3F.
Yes, yes, fair enough. But what are they doing?
So you contend that page 31 is the order of your regularization. Accordingly,
Lord.
they cannot take
31
your
read with 43.
read with 43.
Now read with AICT regulations because we are a technical, so we have to get approval for AICT.
Okay, fine.
So may I just
But everything will boil down to 31.
31, yes, 31 and AICT, because how do they seek approval? You cannot get
Madam,
approval of.
AICT by itself is of no use until and unless the government has done it.
Correct.
Now you say 31 government has done that for me.
Yes, yes, that is.
Yes, Mr. Gogol. She's regularized according to her.
It says you yes respect to approval of TF for plain allowances. Nothing more.
Have you
nothing
filed an
less.
affidavit here?
Nothing more. We have filed those. Nothing more, nothing less.
What do you respond? He has made his response.
Lordship, his simple answer is that this is.
Ex post facto
for
approval.
allowances. Lordship, our advertisement, the 3F advertisement gave us AICT regular pay. There's no question of ex post facto.
Where?
Lordship, the advertisement is at page 44. I know?
Writ petition. Writ petition.
Yes, your Lordship, writ petition, yes. Obliged. Page 44, your Lordship, of the writ petition. It says filled up 3F and Lordship scale of pay as per AICT scale. As per AICT UGC scale.
And where is your first appointment order?
My first appointment order, your Lordship, is very much 3F and that is at page 54. (22 to 21). And it categorically says ad hoc. I'm not disputing that. It says 57 to 182 per month allowance, and this is AICT. So our services mirror regular services. Our allowances are regular appointees.
Madam, mirror regular services is one thing.
Yeah.
You say in terms of page 31, regularized.
Yes. And Lordship, now we were appointed in February 21, page 42, your Lordship. Our post, the sequence is this. February 21, we are appointed as 3F. March 21, 260 posts are created.
Are we taking it up for final disposal?
No, Lordship, I'm just asking the subject.
No, this will have to go for disposal. Let us not again revert to ad hocism. Let us take it up for disposal.
Lordship is taking it up
For final disposal.
today?
Huh?
Yes. Only thing is our affidavit is apparently.
Oh, we'll
not
have it
record.
on. Today is 11.
Lordship,
Tomorrow?
Tomorrow I have a difficulty. Lordship, Friday?
Friday will not be possible.
Friday?
Friday will not be possible.
Then Lordship,
Monday.
Lordship, the next week is difficulty. There's a wedding in the family.
Oh,
Lordship, right,
23rd. 23rd. 23rd.
No, yes, 23rd.
23rd. As agreed to by the learned council for the parties, registry to list these matters again. On Baki, all the parties are represented.
Yes, loss.
Item number 52, 53, na? All same. Are so and so to list these matters again on 24/6/2025 for admission hearing.
Like, Lordship, just one more prayer. There are 3 plus 5, 8 petitioners who wish to withdraw. We filed an IA number.
That day we will see. That day we will see. We'll see on that day.
Obliged, Lordship. 24.
But madam, just
Yes.
clarify.
Yeah.
Just clarify because these things may not be as simple as you're trying to put it.
Lordship, the problem is with the state who wants to continue ad hocism at its own will and at its own convenience.
Can't help it.
Yes, that's the problem.
That's why we don't want to have any ad hocism here. We want to go for final disposal.
That is Devi in 2004. They should have not lasted till 15 more years after that. Obliged, Your Lordship.
But the method is for non-processing my pension case, Lordship. Under old pension rules, Lordship. In this
Item number
regard,
kiman
Lordship,
ito?
very recently, one executive order have been issued. Actually, my case is that, though I was appointed.
What do you want? Old pensions?
Old pension.
Show me how you are entitled.
That's it, very recently one executive instruction.
Huh?
Executive order has been.
What is that executive?
Stating that, let's see, if the process of process of appointment is initiated before two thousand
Will not
five.
apply. Because here you have been allowed to join only after the High Court order. But Mr. H. Talukda, Learned Counsel for the petition. None appears for the respondents. Also, accordingly, for the ends of justice, raised to list these matters again for admission hearing in the month of August 2025. We'll hear it.
I will file one.
Are you finding addition? Yes.
In regards to the arrear salary that is
Ah.
paid, the Commissioner Penalty has communicated to the BDO concerned for preparing and for the proposal
Ah.
of the arrear salary. And with regards to the, if any departmental proceeding has been initiated or not, on oral instruction, it has been said that no DP has been initiated.
So pay him that. When are you paying him?
Your Lordship,
This is of 2020. We are 5 years down the lane. So when are you paying him?
time may be given.
Time giving, I gave you time only. Mr.
AK Ghosh on behalf.
A.K. Ghosh, Learned Counsel, appearing on behalf of the respondent, submit that the Commissioner, Panchayat and Rural Development Assam wide a communication dated 25/4/2025 had required the Block Development Officer, Lakhimpur Development Block 2, submit an area proposal in respect of the petitioner for taking further action during the current financial year 25-26. Also, Mr. Ghosh shall on the next date of listing place before this court the further progress made in the matter. Also, it is to be noted by the respondents that the claim made by the petitioner hearing pertains to the year 2020, right? 2020, and for the last 5 years, his such claim has not been released to him. Also, it is further stated by Mr. Ghosh on instructions that no departmental proceeding have been instituted against the petitioner till date. Also, in view of the above, the respondent shall take all requisite steps for release of the subsistence allowance due to the petition for release of the areas of salary after deducting the subsistence areas of salary for the period he was under suspension, after deducting the subsistence allowance if paid, if ever subsistence allowed paid to him. Also, registered to list this matter again on 23/7/2025. On the next date of listing, the respondent authorities shall place before this court the orders passed towards authorizing to the petitioner his due areas of salary. Yes, Mr. Mugan.
Yes, morning, this matter was called.
None appears for the petitioner on call. I will provide it, this Mr. Right. Finished? Hey, it will